All right, we're good. Alrighty. All right, just a few announcements before we get started. For those of you who are new, audio and video are available for download on the website creditorsincommerce.com. Conference calls are on Tuesdays. Those are free. It's from 7 p.m. to 10 p.m. Information is also on creditorsincommerce.com. The resources section, which has a lot of different resources you guys can use to research different areas of commerce. Be careful, okay? Because not everything on there is creditor information. A lot of it's useful, but be discerning so that you, if it sounds like conflict, if it sounds like going to war with the United States instead of going to peace, bringing a solution, anything that sounds like you're fighting or arguing, probably don't want to go that route. The breaks. If we could, and if anyone in here isn't opposed, when we take a break, let's make it 10 minutes. Okay, back in our seats in 10 minutes. Please don't rush me and ask me questions during the break. At the end of the evening, don't rush me. Let me get all my equipment put away before you start asking me questions. And I think that's it. And we do offer coaching on the website. If you guys, I know a lot of you have tried to contact me personally. We have coaching offered on the website. You can get information on the website on that as well. Okay.
Wait till you have the microphone.
Yeah, wait till you have the microphone before you ask any questions so that those who are on the phone have the benefit of hearing. Okay.
This Creditors in Commerce classroom session, hereinafter session, is the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in this session as applied to the recipient's own personal transactions, cases, or controversy, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in this session. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in this session is relevant to your transaction or that the outcome thereof will be depicted as in this session. The discussion of ideas or procedures in this session is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in this session, and the fact that you may not be aware of these issues may have an adverse effect on the outcome of your procedure. It is the responsibility of each party to understand his own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. This session may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you may contact Brandon by email at harmony@creditorsincommerce.com or by telephone at 702-866-9077.
All righty. Now, that disclaimer, that's the disclaimer, okay? So whenever we talk about processes and I tell you not to do them unless you understand them, that's not a disclaimer, okay? I'm not saying that because I have to say that or to protect myself. It's to protect you and to protect the people you know, okay? Because a lot of this information, if used incorrectly, can damage you or can damage someone else, okay? So be conscious of that and be very considerate of that. How many have started filling out tax forms? Okay. If you don't understand the tax procedures we've discussed, or if you've had somebody else fill forms out for you, make sure you have a complete understanding of what's being done. Don't rely on anyone. I don't care if it's Guru Johnson, who's an expert and has nothing but 100% success rate. If you don't have an understanding of it, don't do it. Okay? Start off tonight, I want to talk about the mirror image. And we've discussed in here the difference between operating in the private, operating in the public, what we call the republic in the private and the democracy in the public. Those who believe that the public system or the democracy is dysfunctional consider that the democracy and the public are a reflection of us. Okay? So if the public seems dysfunctional, it's because we're dysfunctional. Okay? An entity is a reflection of a living thing. Okay? So whenever you're operating in commerce in the mirror image, you're operating through an entity. Okay? Whether it's you as a U.S. citizen or a trust or a corporation, those are entities. Okay? The observations are a mirror image of the observer. Okay? For instance, if I look at a situation, a neutral event, and I make something up about it, it's bad, it's wrong, whatever. That's a reflection of me in that thing that I am observing. Okay? So when you look at someone and you think that they're being a certain way, or you're making up that they're a certain way, that is a reflection of you that you're noticing, that you're observing. Okay, so take that into consideration. Okay, as creditors, we want to be coming from an empty space, a neutral space, so that we're not making up anything about events. Okay, every event is neutral. We give it meaning. Okay, so take that into consideration. Here's a good point. We've talked about not fighting the public, not fighting the government, not fighting at all, right? But bringing a remedy as a creditor. Now, if the public is a reflection, I'm standing here with a mirror, and in the reflection is my corporation, okay? And I start fighting with my reflection. Wouldn't I be insane to fight with a reflection? Okay, so every time you're fighting the public, you're fighting your reflection, you're insane. Okay, don't fight it, fix it. If you see something wrong, you have the power to fix it. Okay? Responsibilities of a creditor. We've talked about coming from not only that space of not making up anything about the things around us, but also everything as a creditor, to be truly responsible creditors and to take full responsibility for what we have. A creditor forgives debts. Okay? Not only your own debts, the debts of others. Okay? So, again, we take a neutral event, somebody does something to you, and you make up that they're a certain way, so you hold some kind of a negative feeling against them. That's not being a creditor. And you're not going to be able to get your remedy or bring a remedy if your stand or your position is one that they're wrong, I'm right. Okay? You're making that up. They're not wrong, you're not right. Okay? Creditors. What do creditors do when they're made offers? They accept them. Okay. And what does acceptance do? What does that do what are you doing with the offer if you accept it? Controlling it, taking title to it, honoring it. Okay? So, creditors stay in honor. Creditors ask questions. Creditors don't make statements. Creditors don't take positions. Now, if someone approaches you with a position, and we say creditors don't make statements. So if somebody approaches you and they have a certain position about you or about what's going on, your questions will be in such a nature to establish what is their position. Your questions will be to uncover the facts. Okay? Another thing a creditor doesn't do is make presumptions or assumptions. And you never argue the facts. Okay? You ask questions to establish the facts, but you don't argue the facts. And creditors, we've talked about in a democracy that's under bankruptcy, like the one we're currently working with, the United States. Everything in the democracy operates under what's known as limited liability. Okay? All corporations, all U.S. citizens, they all operate under limited liability. As a creditor, you operate under unlimited liability. That means complete responsibility. Okay? These are, how many of you have read the 4 agreements? Oh, a couple of people. I was going through it today, and I thought about the actual 4 agreements and how they're pertinent to operating as a creditor. I kind of put them out of order here, but we already discussed presumptions and assumptions, and one of the 4 agreements is you don't make assumptions. Okay? So, for instance, those of you out there who, after we've discussed the tax remedies, you feel that you know what you're doing, I would say rebut that presumption. Okay? Don't make any assumptions. Don't make any presumptions. Don't assume I know anything. I don't know anything. If you can't understand this for yourselves and find the information out there for yourselves, don't take my word for it. Don't even assume once you think you know it, that you know it. Don't get comfortable and in a rut of doing something. Okay? Like when I fill out my tax forms, I don't just do it because that's the way I've always done it. Okay? I don't like to get in a rut and like, okay, this is how I fill it out, this is how I fill it out, this is how I fill it out. Every time I fill it out, I'm thinking, what am I doing on this form? What information am I putting here? What's happening? What am I reporting on this form? Okay? Always be in the question. Always asking yourself. Okay? Don't ever assume you know anything. Another one of the agreements is be impeccable with your word, or be your word. Okay? As a creditor, you want to stay in honor. And staying in honor is being your word. If you say you're going to do something, do it. Don't take anything personally, especially in commerce. It's just business. Okay? No, judges don't attack you. Attorneys don't attack you. When the real estate guy shows up at your house to give you a 3-day notice, he's not attacking you. Okay? It's just business. They're there to do their job. Act as a creditor. Treat them with respect. Treat everyone with respect. Even those who are belligerent. Especially those who are belligerent. And the last one, always do your best, which I just sum that up. Give all you got to all your endeavors and all your undertakings. Don't take a half-assed approach to it. Okay, I've actually I prepared a little outline for tonight because I wanted to hit some main points. So I hope you guys don't mind the incongruity. Okay, here's an important point. Creditors clean up messes. Okay? Debtors make messes. An easy way to make a mess is if you make a presumption and then pursue a process that we've discussed here. Okay? If we discuss something, none of you know what I know. And I don't know what any of you know. So when I talk about things and I discuss things and we talk about a process, a document, I'm speaking knowledgeably, but that's my understanding. And whatever's in my head, I might be leaving out of the conversation. Okay? And I've noticed myself when I go back and watch the videos and listen to the audios, sometimes I think I'm saying something, but I use the wrong words. Okay? So again, I don't know anything, so don't assume I do. Alrighty. I'm going to go over a couple definitions here because we're going to actually get into bailment tonight. For those of you who are on the conference call, where we were discussing financing statements. And remember last week we talked about accepting for value the birth certificate, returning it to the Treasury, and reversing the trust so that you are now in control of the trust. Okay? Well, there's a follow-up to that. And we're going to be discussing records tonight. Public records versus private records. And if you reverse the trust, where was that done? Was that done in the public or was that done in private? Private. It was done in private. So, if it was done in private, is there record of it? There's private record of it, right? Okay, because you should establish your own private record of that event. How might you establish a private record of that? A witness? Affidavit. Is an affidavit evidence? Like how would that establish the record? Is the affidavit going to be accompanied by copies of your process? Maybe a return receipt from Postal Service? No, we're just kind of feeding back right now. And I'm repeating it. So until we actually go into questions, we'll use the mic. Notaries. Okay, so a notary can certify a copy and you would keep that as a private record. Do you record your private records into the public? Why not? Does anyone know? Exactly. A private record typically is in some form a claim. Okay? And a private record that is a claim, if you record it into the public, whether you take it to the county recorder or file it into the public side of a court case, you're giving up title to your claim. So if let's say I have a claim, and it's a notarized document with an apostille on the top, so it's a self-authenticated claim. And I record that at the county recorder, I've now given the county legal title to my claim. I may have equitable title, just like your car, right? You record your title with the state. The state holds legal title. They certify a copy of the title to you, which gives you equitable title. Okay? Same thing with your claims and your records. Your private records are your property. If you put them into the public, you're abandoning them. Okay?
Is there a level of claims, I guess, or title, equitable, legal? Is there a ranking? Or like, does one have a hierarchy over the other, equitable title versus legal title versus?
Okay, the question is there a ranking for title? Does one... Is one greater than the other? Is that what you're asking?
Yeah,
legal title is control.
Okay.
Whoever has legal title controls. That's why the state can take your car, right?
Yeah.
They have legal title.
So legal title is more powerful.
And your house. Who has legal title to your house? No, not the banks. What did the bank do with the deed of trust? They recorded it in the county. So who has legal title to the property? The county. Okay?
So legal title, it has more power than equitable title.
Yes. Legal title is control. Equitable title is owner-operator. Okay? So we're going to go over a couple definitions here to kind of set us up for going into the public records that we're going to use for establishing our position. Let's see. All right. This is out of Black's Law. And this is the definition of principal. One who authorizes another to act on his or her behalf as an agent. Definition 2. One who has primary responsibility on an obligation, as opposed to a surety or endorser. As opposed to a surety or an endorser. Is a principal a surety? Can a principal be a surety? Yes. Okay? And definition 3, the corpus of an estate or trust. Okay? Undisclosed principal. A principal whose identity is kept secret by the agent. A principal for whom the other party has no notice that the agent is acting. That's an interesting definition because when you refuse to take responsibility for your public trust, guess who steps in? Like, for instance, if I'm in a court and I'm being belligerent with a judge, guess who steps in to be the agent? No, the judge. Yeah. The judge takes your responsibility. He assumes that you've abandoned the trust or that you're a dysfunctional trustee. Yeah, especially if you're arguing with him. Okay? So he becomes the undisclosed, or he becomes the agent of the undisclosed principal. Who's the principal? The straw man. The U.S. citizen is the principal. You're the authorized representative. Okay? Can the public even interact with people? No. They can only interact with corporations or entities. The U.S. citizen trust that you formed a partnership with the United States with is who they can interact with. They pull you in because you're the trustee. You're the authorized representative. Okay? You're the surety. Okay? Let's see. An undisclosed principal and the agent are both liable on a contract entered into by the agent with the principal's authority. Okay? Definition of a principal creditor. A creditor whose claim or demand greatly exceeds the claims of other creditors. Okay? It's also considered a paramount security interest. Definition of secured party. a person in whose favor a security interest is created or provided for under a security agreement, whether or not any obligation to be secured is outstanding. If a security interest is created or provided for in favor of a trustee, agent, collateral agent, or other representative, that representative. Okay? A surety. This is an important one. Definition 1 of a surety. A person who is primarily liable for the payment of another's debt or the performance of another's obligation. So, if the U.S. citizen has a debt or an obligation, who do they pin it on? You. You're the surety. Okay? Although a surety is similar to an insurer, one important difference is that a surety often receives no compensation for assuming liability. Does your straw man pay you? No. No. A surety differs from a guarantor who is liable to the creditor only if the debtor does not meet the duties owed to the creditor. The surety is directly liable. Definition number 2, a formal assurance, especially a pledge, bond, guarantee, or security given for fulfillment of an undertaking. Okay? So a surety, does a surety have to be a living man or woman? No. It could be a pledge or a bond. Has anyone ever had to bond out of prison? Oh, yes. Yeah, who's going to... Okay, so what are you doing when you bond out of prison?
Putting your back up for insurance.
You're putting something up, right? Somebody's putting something up to act as a surety for you to appear. If you don't bond, you don't go anywhere. And I kind of threw this definition together by combining the meanings of duly authorized and representative. But it's the word I like to use, as you got to know who you are when you're acting as a creditor and when you're dealing in commerce. Okay? You're never the straw man, the trust, the corporation. You're always a duly authorized representative. Duly is improper form, okay, or lawful. An authorized representative, here's the definition I gave to duly authorized representative. One who is empowered in a proper or lawful manner to act on behalf of another. Okay? Now, we'll get into public record and private record. Okay. Have we ever discussed form and substance in here? No? Touched on it? Okay. Public records have nothing to do with substance. Does that make sense? Maybe we'll move on it a little bit and see if you get the understanding. Okay. Oh. No substance, actually. Okay. Public records have to do with form. Okay. For instance, how many people have ever tried to go to the county recorder and record something that wasn't in their form? Yeah. If it's not in the proper form, they don't take it, right? Now, you could bring them their own codes and show them, it says here you have to record whatever I bring you. That may or may not work. You may have to take it to judicial review to get your process recorded. But my opinion, if you're dealing in the public, in public records, go by their form. Like, you don't want to just throw together a piece of paper, write claim across the top, and write some arguments on it and go try to file it into a court case. Okay? They have a form that you must go by. Okay? The form is in a pleading format. It's got certain titles, certain structure to it. But there is no substance in the public. Remember, all substance is in the private record. Just like your true claim, if the substance is in private and you file it into the public and it's not in that form, in their form, it doesn't mean anything. And when you do take substance and put it in the public, it has no substance. It has no meaning. Okay? What's that?
It becomes subject to public policy, too, at that point.
Yes. Well, you're giving up title to it, for one, and it is subject to public policy, and public policy is microphone.
A couple of years ago, some people were advocating getting your power of attorney, which basically says that the living soul is acting as surety or taking control of the straw man and then filing that publicly. Does that give the state legal title then to that private document?
Yes.
So then you pretty much nullified anything you were hoping to do by that.
Yeah, but you could have taken and just filed a notice into public. Because in public, it's all about form. And a document that's a notice, for instance, how many of you have ever experienced a tax lien? Okay? How many have actually ever seen the lien?
They won't show it to you.
No, because it's private. It's substance. It stays in the private. What do they record at the county recorder?
Notice.
A notice of lien. Form, no substance. Okay? Notice of levy. That's what gets filed in the public. They have a certification of your dishonor somewhere, but it doesn't go into the public. It stays in a private record. Because they know. Substance stays in the private. That's where it maintains its volatility, so to speak. Yeah.
So, if you have substance in private and you put something into the public record and you lose the substance because you've lost the title, so where is the substance then? Because the public, you're saying, can't hold substance, but you've lost it. So where did it go?
Yeah, you basically gave, for instance, if I had a claim, okay, and it was in the form of a self-authenticating document, notarized through a third party. Maybe I had my notary actually make a presentment and certify a dishonor. Okay? If I had my notary certify a dishonor, I've now got a claim. If I take that claim and I file it into the public, it no longer has any weight for me. Doesn't mean the public can use it for anything, but they have title to that document. Okay? So you've only really damaged yourself by filing that into the public. So keep that in mind when we do get into the administrative procedure and perfecting claims. Okay? So over here we have form with no substance, and over here we have substance with necessarily no form. So we'll call this our claim, and we'll call this, should I call this liability? I'll call this notice. Okay. So public records, form or notice, private records, substance or claim. If we were talking is there assets in public? No. So what can we call this if it's not an asset? A liability. Okay? So public records are evidence of liability. That's why you have notice of lien, notice of levy, okay? It's evidencing a liability. Your private record is your asset. But in a bankrupt society, there are no assets in public.
Brennan, you spoke about the public not being able to traverse into the private, and my question is how can a public entity like county recorder, for example, have something of substance in the private in the form of, let's say, the lien? They don't. They shouldn't. They shouldn't be able to traverse into the privates. Therefore, it's only a public document. Therefore, it has no substance. That notice of lien is not backed by a sworn affidavit.
Nope.
And if you ask them for it, they'll never send it to you. Therefore, it's not a valid lien.
No, they don't need substance over there. See, it's Disneyland. They don't need to prove that they have anything against you. Just like the deed of trust that's filed. The bank is alleging that they loaned you money. Did the bank loan you money? No. But they're alleging they did. And they convinced you that they did. So you sign on the deed of trust going, yep, I owe you money. But there's nothing really backing it. I mean, isn't it interesting, the deed of trust, how many parties sign?
You sign it.
One. It's a one-sided contract, right? Did they ever sign something saying we promise to give you money? No. It's a one-sided contract. Okay? Public record. Oh, and we talked about certification of records. If your claim or your private record has a notary seal, or you've had a notary make presentment and you've got certification through the third party of a dishonor or whatever, the notary seal itself is an authentication. Okay? If you add on top of that a certification from the Secretary of State, you now have a self-authenticating document. You can take that claim anywhere in the world and it has weight if you know how to use it. Okay? Now, you're going to have to learn the public records system so that you can file a notice of your claim. Okay? So you may have a claim over here in private, but how do you enforce your private claim in the public? By recording a notice of your claim. Just like the IRS records a notice of their claim. So you use the public records to file notices.
Very good.
Okay? Now we're going to get into UCC filings and how we're going to use the public record to basically make a public record of what we discussed last week about taking control of the trust. We want a public record now that we control that trust. Okay? So the most powerful document that you could file in public records as far as a claim or notice of claim is a UCC 1 financing statement. Okay? Did we do levels of liens yet? Will we show which liens are higher than other liens? Okay. We did. Oh, we did in the first class? Okay. Well, we'll do a quick repeat of that.
Yeah.
Okay. Okay. Okay, the highest form of lien. Anyone? Anyone? Commercial lien. Next highest form of lien. Tax lien. Why would a tax lien be the next highest, you think? Because they're on both sides, private and the public. Okay? So IRS is an interesting agency because they work under the Secretary of Treasury. And we all know Secretary of Treasury happens to be one of those people who expatriates his citizenship in order to serve his role. Okay? So he has the ability to operate in the private and the public. And who is the IRS working for? The creditors. Okay? So whatever foreign creditors own or have a security interest in the United States, the IRS is the one collecting for them. China's just one of them. Oh, this is my opportunity to say Chinese cheesecake. All righty. Next form of lien. Mechanics lien. Next. Mortgage lien. Yep. Okay. So, from most effective to least effective, the highest form of lien is a commercial lien. Next highest form is tax lien, then mechanics lien, then mortgage lien. Okay? Now, this document, the UCC1 financing statement, is evidence of a commercial lien. Okay? Do not use this to file against an IRS agent. Do not file one of these against a judge. You will end up in jail. I promise you. Okay? Unless you actually have a claim, a legitimate claim, which you can back up with your private records, yeah, and then go ahead, file it on whoever you want. But don't get pissed off at someone and go file a commercial lien on them. Okay? Not wise. Okay? So what we're going to do is we want to establish a public record that shows our relationship with the U.S. corporation, or our U.S. corporation, what we like to call the straw man. So, this particular UCC financing statement. Now, there's a lot of information out there. People will try to tell you you're going to file a UCC statement as a living man and you're going to hold your straw man as the debtor. Okay? I'm here to tell you, living men cannot file this form. Is this a public or a private form? It's a public form. Okay? So, if the public cannot interact with living things, can living things file public documents? No. Okay? Now remember, when they established the two trusts, the birth certificate trust is a non-resident alien. He is a member of the republic. Okay? Then your SS5 established a trust, a U.S. citizen. And that entity is a resident citizen. Okay? So, what we're going to do is since we took the birth certificate, we accepted for value, so we took control of the trust. Okay? So now, that individual, evidenced by the birth certificate, we now control that particular trust. Okay? So what we want to do to put a public record of that is we want to establish that our private entity, okay, evidenced by the birth certificate, is basically going to serve as trustee over all of the U.S. citizen or straw man's property. Okay? Not as a surety for the straw man, but as the controller of his property. Okay? This filing is what has become known as a Baylor-Bailey filing. Okay? Baylor places property into the trust. Bailee manages and controls the property. So, who is the bailor? The U.S. citizen, the straw man. Okay, so the U.S. corporation is the bailor. Okay, and who's the bailee? Okay. The bailee. Who's the bailee? Who's the bailee in our situation? Who do we want to make the bailee? The living man. Can a living man fill out a UCC form? Okay. So your non-resident alien. We'll call it your private citizen. Because you're technically a citizen of the Republic. You're not a citizen of the United States, but you're a citizen of the Republic or an American citizen or a California national. However you want to word it, when in relation to the United States, you're a foreigner. Okay? So the bailee is in private. Okay. Here's I actually put together some definitions and descriptions of bailment and the bailor and the bailee. Definition of bailment: a delivery of personal property by one person, the bailor, to another, the bailee, who holds the property for a certain purpose under an express or implied in fact contract. Unlike a sale or gift of personal property, a bailment involves a change in possession, but not in title. Okay? So, can the private entity hold property? Can he get loans? Can he get bank accounts? No. He can't do any of those things. He doesn't have a Social Security number. U.S. citizen has a Social Security number. This guy down here can't do anything in the public. Okay? So, if this is the guy we have to hold all our property in, then it's the trustee or bailee managing the property of the U.S. citizen. Okay, that's what we're putting into our public record. Okay, definition of bailor: a person who delivers personal property to another as bailment. One who provides bail as a surety for criminal defendant's release. Bailee: a person who receives personal property from another as bailment. Now, I've got the rest of this document. This is actually included in the documents for the class. Some of you downloaded it already. The links for that will go out. If you aren't on the email list yet, you'll get it after tonight. The temporary. This is from the Law Encyclopedia on bailment. Okay, we're going to go over this and maybe pull it apart piece by piece. Bailment: the temporary placement of control over or possession of personal property by one person, the bailor, into the hands of another, the bailee, for a designated purpose upon which the parties have agreed. Okay? So, we're actually starting to get into a bailment agreement. Now, on a UCC, our public notice, there's a box down here called collateral. Okay? And in my collateral box, I have listed on here, this is actual and constructive notice. Okay? All recorded property, real, or in parentheses, real/personal, belonging to the bailor is hereby placed into trust with the bailee. All unrecorded property, real or personal, belonging to the bailor is hereby placed into trust with the bailee. All relations and agreements between the bailor and the bailee are covered in the following private documents. Contract of bailment number, blah, 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 and power of attorney number, blah, blah, blah. Okay? A contract of bailment is basically setting the terms upon which the bailee can control the bailor's property. Okay? The term bailment is derived from the French bailor, to deliver. It is generally considered to be a contractual relationship since the bailor and bailee, either expressly or impliedly, bind themselves to act according to particular terms. The bailee receives only control or possession of the property, while the bailor retains ownership interest in it. During the specific period of a bailment exists, the bailee's interest in the property is superior to that of all others, including the bailor. Let me read that again. The bailee's interest in the property is superior to that of all others, including the bailor. Okay? Unless the bailee violates some term of the agreement. Once the purpose for which the property has been delivered has been accomplished, the property will be returned to the bailor or otherwise disposed of pursuant to the bailor's directions. A bailment is not the same as a sale, which is an intentional transfer of ownership of personal property in exchange for something of value. Not anyone aware of any sales going on? A rental or lease of personal property might be a bailment, depending upon the agreement of the parties. A bailment is created when a parking garage attendant, the bailee, is given the keys to a motor vehicle by its owner, the bailor. The owner, in addition to renting the space, has transferred possession and control of the vehicle by relinquishing its keys to the attendant. If the keys were not made available and the vehicle was locked, the arrangement would be strictly a rental or lease, since there was no transfer of possession. Let's go to that. Categories, elements. You guys probably want to go through the whole document when you get it in the email or if you download it off the site. I'm going to skip around here. Okay. A requisite to the creation of a bailment is the express or implied acceptance of possession of or control over the property by the bailee. A person cannot unwittingly become a bailee because a bailment is a contract. Knowledge and acceptance of its terms are essential to its enforcement. So remember what I listed in the collateral? Contract of bailment. If you don't have your private claim, your contract of bailment, you don't have a bailor-bailee relationship. Okay? Consideration. The exchange of something of value must be present for a bailment to exist. Unlike the consideration required for most contracts, as long as one party gives up something of value, such action is regarded as good consideration. It is sufficient that the bailor suffer loss of use of the property by relinquishing its control to the bailee. The bailor has given up something of value, the immediate right to control the property. And another little point here under rights and liabilities of the bailee. The bailee can use the property only in the manner authorized by the terms of bailment, which again falls under the contract of bailment. Okay? That phone. Ooh.
Turn it on.
So not to be redundant, but just to be really clear, you just described what happened when our birth certificates were signed by our mother.
Let's see. Was the birth certificate signed by your mother?
No, but the birth certificate, the first agreement that happened where our parent gave up property, gave us up as property to the structure of the land, the rules and such.
They gave you up?
Well, when they signed our birth certificate,
Did they sign a birth certificate?
we became a ward of the state or whatever.
Did your mom sign a birth certificate? She signed an application for live birth.
Yeah. Yeah.
No, application. It's an application. She's applying for you to have a space in commerce. It's a manifest. Anyone familiar with what a manifest is? Okay. A manifest, just like a manifest, it describes the vessel. Okay? Your weight, your height, even your footprints go on it. That's the application for live birth. Okay? So, if there is a Baylor-Bailey relationship there, it's not expressed.
That again.
So, is it a Baylor-Bailey relationship? Didn't we just discuss that it must be expressed in order for it to be bailment or a bailment agreement? David's calling.
Well, I guess I'm just trying to see the final puzzle piece of how come we're able to actually accept for value our birth certificate, because now we actually know what happened, and now now we're taking on this relationship with our straw man.
Right, but that's this guy. This guy wasn't created with the birth certificate. That guy was created with an SS5. Right? It's a partnership. The SS5 is a partnership. This entity down here partnered up with the United States Corporation to create this thing up here. Okay? And for those of you who only have the benefit of audio, the private... I have to remember that. The bailee, or the private citizen, got into a partnership with the United States Corporation to establish the bailor, or the trust, or the corporation, or the U.S. citizen. Okay? 4 minutes to switch tape? Okay. So, when I fill out this form, I list under debtor. See, it doesn't actually say bailor, bailee on a UCC1. There's a debtor and there's a secured party. Okay? Which one is the bailee? You think it's the secured party, but who's placing the property into the trust? Bailor, right? So the secured party is actually going to be your trust, all caps. So do you see the problem with everyone running around filing their upper lowercase name as the secured party and their trust as the debtor? Microphone. Okay.
Can you correct a previously filed UCC1 if it was done incorrectly?
You can terminate it.
You can terminate
it.
Okay.
You can correct it.
Okay. And what's with people putting transmitting utility down on that?
Okay. We'll go into that. Let's switch the tape and we'll go into transmitting utility. Here we go. You ready? All right. Okay. Transmitting utility. I suggest everyone in here, before you file one of these, read Article 9 of the Uniform Commercial Code. Okay? And look up transmitting utility. Transmitting utility has nothing to do with what we're filing. Okay? And in fact, if you were to actually mark the box on here, it says debtor is a transmitting utility. Is the debtor the bailor or the bailee? Bailee. You don't want to be a transmitting utility. Okay? Alrighty, so down in box number 5, this is where you make the distinction of bailor or bailee. Box number 5 is alternative designation, an alternative to secured party and debtor. Okay, you could be a lessee and a lessor, or a leasee or a leasor. You can be a consignee and a consignor, and you can be a bailee and a bailor. You could be a seller or a buyer, or you can mark it non-UCC filing if this is just some kind of public record you want to create. So that's essential to establishing the bailor-bailee relationship, is that checkbox in box number 5. This is what's called financing statement amendment, or a UCC 1AD. Okay? Did I say amendment? Yeah. Addendum. Okay, it's addendum. I didn't mean amendment. Addendum. Okay, needs the name of the bailee at the top. And there is another checkbox down here at the bottom, box number 17. And the box you will check is trustee acting with respect to property held in trust. Okay? It's as simple as that. So we've just gone through a UCC filing. Yes, this is actually on the website. You will get it in the downloads, this particular sample, okay? Alrighty. And this is a UCC 3, which is basically an amendment to a UCC 1. So somebody just asked the question, can I change? This is what you use to make changes. UCC 3. It's an amendment. Okay? You can do a termination, a continuation, an assignment. So if you're taking a security interest and assigning it to someone else, you would use this form. If you're amending the debtor or creditor or debtor or secured party or bailor or bailee information, you'd use this form. And it's much like the UCC 1, except you have to put the number of the UCC 1 filing on it and whatever information's changing. It's pretty self-explanatory. The instructions for these forms are also included in the download, so you have complete instructions on filling out these forms.
Do you have to do a UCC 1 every year?
No. How long do they last? 5 years? 10 years? What's that? No, it's a couple years. I forget. Yeah, it's somewhere between 3 and 10, we'll say. I forget the actual duration. It's 5? Okay. And that was the purpose. If you did a transmitting utility, it doesn't expire. That's the difference of a transmitting utility. Okay? But that's creating something in perpetuity. We don't want to necessarily create something in perpetuity. There's a sample power of attorney also included. I wrote this one basically now, this is just a standard general power of attorney. Okay? I didn't really go through it and pay too much attention to it, but it's a complete general power of attorney from this guy to this guy, or from the straw man to the public citizen to the private citizen. That's what I'm going to call him from now on, okay, guys? Just to keep from using so many different terms. Public citizen is the U.S. citizen, the SS5 trust, the member of the democracy, okay? The private citizen is the trust established by the birth certificate, the non-resident alien, okay? So just to keep it clear and to make it simple, we'll call it public citizen, private citizen. Alrighty, and there's...
Let's go back to the UCC for a second.
Yeah.
Can you go over if it's something you file just in your state or nationally or in your birth state and your living state, or if it matters?
Okay, public records. If I file a UCC-1 in the state of California and I wish to enforce that UCC-1 in the state of Oregon, it would be a good idea to get a certified copy from the Secretary of State. If it's filed in the county, you could get a certified copy out of the county and then get a certificate from the Secretary of State on the seal of the county. When you get the certification from the Secretary of State, it's anyone ever heard of the Convention de la Hague?
Yep.
Okay. Convention de la Hague basically established the legalization of international documents through certification and apostille. Okay? If you get a certification or an apostille from a Secretary of State, in California it's the Secretary of State. If you go to Utah, the actual person that serves the same role as the Secretary of State is the Lieutenant Governor. So in every state, there's a representative that can apostille or certify documents by officials in that state. That includes a notary. You can get your notary's seal and signature certified by the Secretary of State. When you do that, it has now authenticated or certified that document for use anywhere and for recognition anywhere. A notice in California is a notice to the world. Okay? I just have to take that record and bring it with me certified to enforce it. And you may want to learn if you're going to try to enforce a claim in a foreign nation, you may want to learn how their commercial registry works. It's not going to work the same as ours. Okay? So like if you're going to the UK with your claim, you have to learn what the UK's equivalent of UCC filings are. And then put your commercial into their commercial registry. Okay? So to answer your question, or does that answer your question, I should say? Okay. Alrighty. Any other questions on UCC's?
The certification
Yep.
by the Secretary of State.
Oh, let's get it on the mic so they can hear it on the audio.
Hello. The certification by the Secretary of State doesn't produce a disqualification of your private position?
No, because what are we certifying? Well, if we're certifying a UCC document, is that a public or a private document? It's a public document. So if I certify it, has it changed the status of that? No. Okay? Now, here's the interesting thing about a Secretary of State, because if I took my claim and got an apostille or certified, would I be handing it over to the public? No. Because, remember, who are the 3 U.S. officials who expatriate to serve their role? Secretary of State, right. But who does the Secretary of State of California, Deborah Bowen, work for? No, she works for the Secretary of State, who's Hillary Rodham Clinton. Yes. Okay, so Secretary of State, Attorney General, and the Secretary of Treasury all have to expatriate to serve in their positions because they need to be able to operate on the private side. They're actually, those 3 people are the defenders of the Republic. They're the ones who defend the rights, the private rights, the assets. If we didn't have those 3 people, we would only be able to operate strictly in the public, which can't really happen.
We're actually depending upon Hillary for that position.
Yes.
Isn't that great? That's marvelous.
Yes. But the good thing about it is that she expatriated. And her role, it serves a private and a public purpose. So if I take my private document, which may have a notary seal on it, and I get it apostilled, it's still private. I didn't record it into the public. An apostille or certification does not record the document, nor does it doesn't authenticate the contents of the document. Okay? So the contents could say, Jack is a jackass, and I could get it notary sealed, and I could get it apostilled, and if I take that to England and give it to Jack, it doesn't mean he's actually a jackass. The Secretary of State's not testifying that he's a jackass. Secretary of State's just saying, yep, that notary is legit. That's all the Secretary of State is doing when she certifies my document. She's just saying it's legit, that's a signature, that's a seal. Wait. Somebody else has my phone.
Is there a Secretary of State of California?
Yeah, Deborah Bowen.
Okay, does she expatriate?
Not necessarily. I don't know. Maybe she does. I don't think she does.
Do any of the Secretary of States for any of the states?
They don't have to.
They don't have to.
Mm-mm. They're working just like a notary public. A notary public can actually operate on both sides. If you read the code of the California Government Code for notaries' duties, they actually have, and it's funny because it's an interesting little clause. It says, a notary public may perform any of their duties without the state of California and without the United States. What does that mean? The private side. Without the state of California means they don't have to do it within the corporate state of California. A notary is a preservation of the old notary. Notaries used to be the equivalent of a peace officer or a justice of the peace. Okay? They operate on both sides, the private and the public. Or at least they have the capacity to operate on both sides. Does anyone know who are notaries the agents of? Who do notaries report to? Who's their direct superior? Secretary of State. You see how it falls down, the dominoes there? Secretary of State, Hillary Rodham Clinton, she gives up her citizenship. She can operate in private and public. All the Secretary of States of the many states all work for her. All the notary publics work for the Secretary of State for the individual states. So, all of those people that we just discussed, notary publics, Secretary of State of California, and Hillary Rodham Clinton, have the capacity to operate on both sides.
Has it always been that way?
Ever since we lost the republic, ever since we've been operating as a democracy and a republic.
So it's 1873 or what?
About that time, late 1860s, sometime around there, when the U.S. corporation was established. Now, it wouldn't have been a straight transition from one to the other, and 1860s through the 1890s, I would say, is probably when it happened, when they established those rules for the democracy.
Well, Treasury agents have to expatriate, or do they work for the private sector?
The question is, do Treasury agents have to expatriate? And my understanding, no, they do not. Yeah, the Secretary of Treasury is expatriated. And I'm not sure about this. No, well, at least under the U.S. Code, there are no other government officials who expatriate. But there is an agency which can operate on both sides. And that agency is the U.S. Post Office. Okay? So there's two sides to it. The Republic side is the U.S. Post Office. The democracy side is the United States Postal Service. Okay? Perhaps. But he doesn't. I'm not aware that he expatriates. It doesn't say in the U.S. Code that he has to. Right, exactly. Or his position's been abandoned. Maybe there is no Postmaster General of the Post Office. There's a Postmaster General of the Postal Service, but that doesn't mean that there's one for the Post Office. Do you have your letter? Yeah. Let me see it real quick. Did we discuss last week about the 3-cent stamp? Yeah. Here's a piece of mail that just went through for 3 cents, proving the private side. Do you care if I pass it around? Okay. What he did was he put in the upper left-hand corner, general delivery, with the address of his post office, okay? Down here, the person he addressed it to looks like himself at his address, except he added a line under his address that says, non-domestic without the United States, okay? This is private mail. And by the Universal Postal Union's guidelines, all private mail must be delivered for, actually I think it might be 2 cents, but we did it for 3 cents. So you guys can take a look at that.
Is there a 3-cent stamp then on it?
Yeah, it's a 3-cent stamp.
Did you have to put care of?
No.
You use zip codes and everything.
Yep, he uses zip codes and everything. Yeah, because it's general delivery, because that's private. If he'd have put his public address as the return address, it wouldn't have gone through.
And you couldn't use a P.O. box then either. In place of the actual address, you can use a P.O. box?
No, you cannot. That's public too.
You can mail it in its own post office.
Did you mail it from a post office or drop it in the mailbox? Drop it in the mailbox.
Where were you mailing it from? Where to where?
The post office by my office to my house.
Just for fun?
From the post office,
Okay.
from the post office by his office to his house.
Got there pretty quick, too.
Yeah. I think they sent it out.
Oh, and by the way, that only works for envelopes like this. Don't try taking a huge box, putting a 3-cent stamp on it, and mailing it. It ain't going to work. Okay? But you could try it. And if it works, let me know.
Last week they were going to do return and make it work.
Somebody who's going to try a box?
I think so. They talked about last week.
Okay. Alrighty. Something I wanted to read over for those of you who have been... anything else regarding bailment, bailor, bailee, UCC filings? It's microphone. I'll get to you guys on the phone soon, too. Shucks. I don't think so. I think I'm still on the phone. Yeah, I'm still on TalkShoe.
Yes, I would like to ask if you can give us a brief explanation of the expatriation for these people, for those officials, and what happens when they come back in from the office.
I don't know if they ever come back in. What you want to do, if you want to read the details about it, it's somewhere in, I want to say, Title 22 of the U.S. Code. Okay? So,
Federal regulation.
no, U.S. Code. U.S. Code. Well, there'll probably be a CFR side to it. CFR is the regulation side of the U.S. Code. There's a microphone right behind you.
Well, you sometimes cover, I don't know if you want to do it tonight or some other time, but more in detail the deed of trust and how that transaction, you know, you talked about we signed a promissory note and things like that.
I have a question about that. We were some deep discussion today.
Okay, about the credit application and the deed of trust?
Yeah.
Okay.
And how does the 1099 and all that, but we didn't get into the process.
Okay, well, let's finish up on bailment, UCC, and then we'll get into that stuff. Any other questions about bailment, UCC, public records, private records, any of that?
I do have a question about that. Okay, so you've made it clear that you don't necessarily need a power of attorney or a security agreement or a hold harmless indemnity affidavit.
Your bailment or your contract of bailment can include those things.
Okay.
A hold harmless or indemnity clause
Uh-huh.
can be in your contract of bailment.
Okay.
Okay.
So I have all those things that when I filed my UCC with Secretary of State that is supposed to, that I have for my private record. I just haven't actually produced them yet.
You're going to want to terminate that.
Okay.
I noticed the language on it today. Well,
Okay.
I'm
Yeah.
not telling you.
No, right.
But from my understanding, I went back and read it.
Yeah.
And it's got the bailor and the bailee switched around. Not on the actual form,
Uh-huh.
but in the collateral box.
Are you sure?
Yeah, it says...
'Cause I thought we
it goes-
read it a bunch.
No, it says secured party, and then
Yeah.
in parentheses, bailee. The bailee's the
Huh.
debtor.
I thought we
And
switched
there
it
is
around.
no debtor or secured
Right,
party.
right,
We're
right.
replacing them
That's-
with bailor, bailee. So there's language issues
Okay.
with that
So terminate that
collateral.
and redo it again.
I would if I
Yeah.
were you.
I didn't bring it with. Actually, it is in the car. I'll look at it.
Okay.
Okay.
Any other questions? Bailey, UCC, you have a question? Oh, Niall's got a question.
Is it important for this particular process to be filed in order to represent, to stand as a responsible party or an operator in any type of proceeding that would happen to make it into a public tribunal?
Wait, say that again?
Is it important to have filed the Baylor Bailey in order to stand as the operator of the public trust in the event that any proceeding makes it into a public tribunal?
Let me ask you. When you walk into a court, how do they see you? They do.
Spoken from an attorney.
That's actually right, but that's because we're in Admiralty. He's right. In Admiralty, you're guilty until you prove yourself innocent. That's how Admiralty works. So, but really, the U.S. citizen. Does a judge know the difference between a U.S. citizen and a man? He does. He doesn't think you're a U.S. citizen. But if you go in there arguing, I'm not the straw man, I'm not this, and I'm not that, he's like, yeah, okay, alternative reality disorder, and you're the trustee. You're the one responsible. You may not be a stack of papers, but guess what? You're the guy we tagged them to. Yeah, you're the surety. So, to answer your question, is it necessary for you to really have the Baylor Bailey filing to walk in there as a trustee? You're already the trustee. You're just establishing the bailment agreement. Like, really, it's about the contract of bailment and putting in a public record that you are indeed in control of the trust as a foreign private citizen.
If I understand that correctly, then basically what you're really establishing is your foreign private situs trust on some level.
Yes. Remember, that's why we took control of it again. We're not sure if you had subrogated. See, when you got into the agreement with the United States, you may have subrogated all the rights you had as a private citizen. And if you subrogated those rights, you might not have them. That's why we take control of the trust. Okay? Take control of the trust, put out a public record as such, and now you can operate. Okay? It's not about creating immunity. Remember, creditors don't need immunity. They're responsible. Okay?
Have you gone over, or will you go over the contracts in the?
Yeah, it is.
Yeah, it's on. I just talk softly. I'm going to go over the contracts behind the UCC that you discussed.
Actually, I haven't put together a bailment contract.
You have or haven't?
I have not, but I will. We can go over it probably in a couple weeks. But I would say, I mean, it should be like a trust agreement. I would probably take one of my trust agreements that I created for one of my trusts, rework it a little bit, reword it a little bit. It's a private. It's an express trust organization. Yeah. So I would probably do it in some form or fashion to that, something similar to that. Okay. Alrighty. Do you guys need a break? Yeah. Okay. Hold on just a second. Hold on. Don't get all crazy. Don't get all crazy. Anyone on the phone have any questions? No? Silence is acquiescence. Yeah. Anyone on the phone have a question?
No.
No? Okay. No. We're going to take a 10-minute break. If you guys want to hang up, that's fine, but make sure you call back into this number. I'm going to stay... Oh, wait, I better not stay connected. I just realized it's costing me Skype credit here to be connected. So what we'll do is I'm going to hang up. The conference call will stay on, I think. We're anxious to get into some of the financial stuff. You guys had questions about notes and deeds of trust and whatnot? Okay. Let's, I guess we'll start with that. Go ahead.
So it's more of just trying to think through the process of what happens when you sign for a loan and the different negotiable instruments that are the promissory note is your promise to pay that loan amount. That's just for the bank. And then there's the note itself that is paid when if you're buying a house, for example.
Okay, we'll go over that. Alrighty, so what's the process of getting a loan? What do you have to fill out first? Application. Okay. Credit application, right? Loan application. Okay. Is your Social Security number on the loan application? Okay. Is your Social Security number on the promissory note? No. Okay. So, application goes in for your credit. Okay? Now, what the bank wants to determine is, are they going to be able to get you on the hook? And if they get you on the hook, are you going to actually make payments and fill their coffers? Because what basically happens when you deposit into your promissory note with an application to the bank, it's like depositing a check. Okay? Here's the ledger of the bank. Okay? Asset side, liability side. Promissory note and application come over here on the asset side. So let's say it's a loan for $100,000. So you've got $100,000 over here on the asset side. Okay? Whenever you deposit an asset into the bank account, the bank gets authority from the Federal Reserve to put liability funds over on this side. Okay? So as soon as 3 days after your application goes in, this money is sitting here. Okay? Now, the bank's going to go through, it was tough getting you the loan. We got to add some points. You're going to have to come up with a bigger down payment. They go through that game. But in reality, the funds are sitting there. Now, where do these funds go? These liability funds right here. They go to the seller. So, liability funds go over here to the seller. Your asset's sitting there in the account. Then they get you to sign the promissory note and trust deed, which basically creates another account. Okay? This account, basically they get you to sign on, and let's say after they added their interest and everything, they make it out and it's going to be, $190,000. Okay?
That's the note? That's the deed.
I would say it's both, because the deed of trust is nothing without the security. Okay? So they basically get you to throw some funds up into this account, right? Now this itself is a security. Okay? So this security has a future value. Okay? When I bundle this security with a whole bunch of other securities, it's going to be making a couple $1 million a month based on all the payments that are coming in, right? Then the bank sells this security to some other investor, okay? And the investor is buying this based on its future value, however much money it's bringing in. Now, the transaction that bought the house, that took place. It's done. You made a deposit. The deposit went over to the seller, okay? Did the bank loan you money? No. Can a bank even create money? No. Only you can create money. That's the beauty of this system, is that only people can create money. Okay? So, if we're creating the money, and the money, when you deposit an instrument, whether it's an endorsed check or a promissory note or any other asset, they get the liability funds automatically right here. Okay, remember we went through the whole Federal Reserve ledgering? Do we need to go through that again? You guys remember that? I know that's probably... See, to me it seemed real easy. So when I was drawing, 5 ledgers on the board, it didn't seem like... No, I'm gonna erase this and show you how it works with the Federal Reserve. Okay, hold on. We got questions. It doesn't matter. Just hand it to someone.
On the board, I'm seeing 100K on the left. On your diagram on the right,
Mm-hmm.
I'm seeing 100K on the left as if it's an asset. I didn't give the bank any money, but you're still saying there's an asset.
No, you gave them money.
I gave them 100K?
Mm-hmm.
Then I wouldn't need to borrow it from them.
Exactly. But they're
I thought
not
we're
going to
talking
just.
about
But they're
applying
not
for a
going to.
loan.
They're not going to perform this transaction for free. Okay, that's the whole point of the bank. Now, the banks aren't bad. I mean, have you seen how bloated a bank is? Can you imagine the kind of overhead these banks have? They need to make their money. If all they did was let you deposit your promissory note and they sent the funds straight to the seller and they made zero on every transaction, our banks would be gone. They wouldn't be non-existent. They need these securities over here to survive. Okay? And every time you make a deposit of funds, like every time you make a payment, okay, whoever the holder of that security is, any liability funds you send in the form of a check, cash, money order, whatever, those funds increase the reserves of the bank. Whenever you increase the reserves, it increases their capacity. Okay? If I'm a bank and I receive $1,000 in reserves, I can fractionalize that $1,000 and make $10,000 out of it. Okay?
Okay, so my question again is, even though I didn't give them any money,
You did.
I gave them a promissory note.
A promissory note is money.
Oh, it is money?
It is money. It's the same as a check.
Just a promise to pay. But it's treated like an asset?
It is an asset. They get the funds directly from the Federal Reserve. They don't take $100,000 of their money and give it to you and send it to the seller. Again, they'd be broke. If they were, I mean, look at how many people are defaulting on their loans now. You think the banks are in trouble now. If they were actually loaning you the money, they'd have been gone a long time ago.
Okay. So, but basically, I haven't parted with any money by giving them a promissory note.
Your signature creates money.
Okay.
Basically, whenever you sign a negotiable instrument, you're giving it. Here, let's go into the courts. Remember, we said the courts work just like banks, right? Okay? So, when a court case is opened, a deposit is made. What's the deposit? The claim, a signed complaint. Okay? That's a money order. It goes into the asset side of the court ledger. Do you know where the original complaint is held? Judge's chambers. In a vault. Because it's money. You can go get a copy of it from the clerk, but it's just a copy. The original charging instrument is held in a vault.
Well, I was just wanting to clarify. So that first 100K you put in there on the asset side on the right ledger, that's money that was created by our application signature.
I think it's probably the application that actually puts the money over here. Because I know the funds are there 3 days later. The funds are sitting in an account 3 days after the application goes in. Then they play the game of getting a bigger down payment. And what's funny is, remember we talked about what's the minimum down payment, at least 10%? Remember, if you make a deposit, they can fractionalize that. So basically, they made their 100K back off your down payment.
How do you know that? How did you find out that?
The 3 days later, TT&L. You could track TT&L transactions. Okay, so you go basically, if you go in and find the TT&L transaction that was conducted on your number, because it was your number that generated the funds, you can find that 3 days after that application went in, there was a TT&L transaction conducted between the bank and the Federal Reserve. Okay.
So Brandon, so then where did you? So the deposit on the right under liabilities came along at the same time the one on the left did?
Yes.
Okay.
See, what
Just to
happens
balance
is,
it out?
see, the banks, they can't do anything with this asset But liability, like when you have for instance, when you have a checking account, okay? Mm-hmm. The checking account, you make a deposit, it's an asset, but the bank gives you access to it through the liability side, okay? Your balance on your account is this side of the ledger, of the bank's ledger. It's their liability, right? Because you can take the funds out. So it's their liability. They're holding an asset. Remember, we went over this with the original issue.
Okay, so when we got to the 190K over on the left, that was what? What are we giving? 90,000,
and that's the promissory note.
That's promissory.
With the deed of trust attached to it.
Okay.
That includes the
interest. No, down payment is another deposit. So we have a different ledger here for the down payment. You basically you gave them $10,000, so you got 10K right here, 10K, and because you don't access that liability, they can fractionalize that. See, when they transfer these funds out of the liability side of here, this is dead now. They can't fractionalize this because they had to transfer these funds to the seller. Okay? So this is just an asset. It's just sitting there. It's a security.
What happens?
Hold on. Microphones, make sure. Okay.
Quick question about, you were talking about the courts, and that is the claim, the signed complaint, is the asset.
Yes.
And then, obviously, we have to have a corresponding liability. So that either is your Federal Reserve notes that you use to pay, right, to offset the liability?
Exactly.
Or the bond created.
It's the job of the court to figure out who's going to put this deposit in.
Right. Therefore, if we give them a bond or if we acquire the claim, then we have a balancing of the double bookkeeping.
Let me ask my attorney. Are you required to have a bar card to be an attorney? Are you bonded through that bar card? Okay. She's the insurance on this money when she files a complaint. She's guaranteeing with her bond that something's going to come in on the liability side. Okay? And that's why you walk in there, you're not an attorney, they don't even like to talk to you. You're not bonded. You're a liability to the whole court. Okay? Everyone else in there is bonded. The bailiff's bonded, the judge is bonded, the attorneys are bonded, the case is bonded. You walk in there, you're not bonded. You know, you're a liability. Literally. Yeah. Very dangerous.
What happens if you turn in an application and you get denied the loan?
The reason you're getting denied isn't because the funds couldn't get here. It's because they don't think they're going to get you to pay on this over here.
Right. But it still created a security.
It still created the security.
So is it still sitting there?
So that's actually money that you can get back then?
Yeah, it is. If you knew how to get it back. We've been discussing methods of getting all these funds back. Right. Because every time you create money, it's yours.
Right.
But what happens is it sits here for 36 months. They can't touch it for 36 months because that's what the IRS says they have to wait before they can declare it abandoned. After 36 months, they declare it abandoned, and they can now fractionalize it.
So 36 months. So they must be making a lot of money. How are they in trouble?
What's that?
I said, when I look at that picture, that they're making a lot of money. How are they in trouble now?
I don't know. How does a business that runs at 500% profit get into trouble? It's a good question. I think it's because they're not efficient and effective enough. Now, there's a downsizing of the entire banking industry going on. Okay? This is almost intentional. It had to happen. Okay? The industry became way too bloated. You had way too many banks with way too much overhead. And that's what's created the problem that we have. And because we are not creating enough funds, they don't have the liquidity. See, liquidity is this stuff over here. They can have millions of these, but they can't do nothing with it if they don't have this stuff over here. This is the liquid. This is what they can move around. Okay, they can't move these around. They have to hold these. 36 months. And then they have to. The Federal Reserve has to buy it from them. If they can't sell it to the Federal Reserve, then they're just stuck holding it for even longer. But if they go to if the Federal Reserve says, yeah, you can increase your reserves, they're going to go, okay, here's our securities. Federal Reserve takes the securities. They get these funds over here from the Federal Reserve, so now they can fractionalize it. Okay? Yeah, anytime you have reserves are what they have to hold on to. And then they can create 10 times whatever their reserves are. Okay, that's fractionalized banking in a nutshell. No, they can, I know.
They have to get the DVD.
Yeah,
Or
DVD will
video.
maybe be a little better.
So these are two completely different transactions. That 100K on the right does not go over there. That's just the promise to pay from our signature. The 190.
This one.
The 190.
Yeah, the 190 is
the
a separate
100K
security.
is a totally separate amount.
Yeah, totally different.
That's what I thought. And the note.
This is what you default on. This is what they foreclose on. This is what's attached to your property.
And so that 190K, is that the amount of, like the promise to pay is what you promise to pay upon maturity of the loan? Like you're promising to pay 30 years, X percent rate, and the principal. So principal, interest, all that stuff, that's the maturity of the loan for the 30 years. So that should be what's in that escrow account on that left side.
In an escrow
so
account.
That whole amount, the full redemption amount versus just the amount
There's
on the
people
note.
who are claiming this back.
That's what I'll be doing.
Yeah,
Yeah.
they're getting them back.
So
if you do it right, you can get it back. If you do it wrong, you're going to get a frivolous filing penalty. Keep that in mind. Which to me is no big deal. I know how to handle a frivolous filing penalty. I've had 2 in just the last 6 months. Okay, so I had 10,000 in penalties to pay, but I know what I'm doing. I'm not afraid of the IRS. To me, the IRS is my best friend. As far as I'm concerned, they're the only honorable agency out there. Yeah, right? That not many of the people would agree with that, but remember, who does the IRS work for? They work for the creditors. So if you're a creditor, they're working for you. When you start to become familiar with all these processes, you're going to be sending in suspicious activity reports to the IRS on the banks. You're going to be like, hey, this bank is doing some funny business, or this court, they're not ledgering my 1099-A. I had a friend in Florida. He does the conference calls, and weeks ago, you guys could probably find it if you go through the conference call archives. He was discussing a case that he was dealing with in Florida, and they had put in the 1099-As and whatnot, and the case was just sitting there. It was sitting open. They weren't closing it or anything. They followed up with suspicious activity report. And it was I think they had put in like bonds and notes, and I want to say the amount was like $6 million or like some crazy amount of money that they had put into this in private instruments. Because the amount was so high, IRS showed up at the court saying, hey, I heard you guys got $6 million. Not only do you owe us the $6 million, but you owe us tax on that. They went and collected $8 million from the court. The court doesn't want that guy back. Okay? So, keep that in mind. No, it's 3949A. Is a suspicious activity report. And tax transcripts, again, if you guys want to get your tax transcripts to clean up your messes, 4506T.
So just another question about this. So I'm just trying to put together like with the deed of the house and
the deed is something totally different.
That's what I
remember. Whose name is on the grant deed?
Our name.
Yeah, and who is the bank's name on it?
Well, the grant deed has to do with land patents. And
Isn't it interesting that after they foreclosed on your house and had a trustee sale, do you know what they're selling at the trustee sale?
Just the promissory note.
The bank's interest in the property.
Okay.
The bank has an interest evidenced by the deed of trust. But they're not on the grant deed.
Right.
So even after the trustee sale, guess what you got to do? Quitclaim deed.
Quitclaim deed.
Because if you don't sign a quitclaim deed, you've still got the title. The bank can't do anything with it. They made you think they sold it. Like, yeah, we sold it. The same bank that loaned you the money bought it.
Right.
Coincidence? I think not. It's because in this market, nobody's going to be selling anything. So you're going to see Countrywide forecloses on you, and Countrywide bought your house from you. Right. I'm sure. Let me see the money that changed hands. Let me see that TT&L transaction. Give me the details on the transaction. I want to see Countrywide pay Countrywide for my house.
Yeah.
It doesn't happen.
So I guess on this transaction, the not the deed, but what's the security for that $190K? Is there okay, right? But is there anything that's attached to the house with that?
Yeah, the
Okay.
the trust
The deed
deed.
of trust.
The
Is
deed
that-
of trust says, basically in the deed of trust in the languaging, it mentions the note.
Okay.
The note is the security.
That's what I thought.
Okay, and they're attaching the deed of trust. They're basically promissory note and house come together on the deed of trust.
Okay.
Okay, so the property is now connected to the note. Okay, through
right.
the deed of trust. Is
No, the note is your promise to pay.
Right.
The deed of trust is the security for that note.
Right. Got it. Deed of trust is the security for the note. Because that's what lists the property, right?
That makes sense.
Right.
Yeah, that's the actual.
Yeah.
That's the actual physical collateral.
The house.
Yeah. So now another question that's related to this: if you refinance, okay. So you have a note that says $100,000, and you refinance your house,
right?
And they reassess it or reappraise it for a
Right.
higher amount, so then it
Right.
goes to 150. And with a different bank, does the original 100 get closed, or is that still an open escrow account?
Okay. We're talking about this over here. So I refinance. So let's say I owe, like you've got equity now, right? Okay, so I owe on this $180,000, and they refinance me for $200,000. Okay, that closes. Remember, the bank who refinances you, they're not holding this security. Some investor is. So the investor just got a huge payday. They're not just getting they're making $1 million a month. Remember, this security gets stapled with thousands of other ones. Okay, they're making $1 million a month off it. Let's say. Then you pay it off. So that month they made $1.2 million. Okay, so that's all that happened. But now you've created a new ledger.
Right. That's what I thought.
Yeah. No. There's the investor on your original note. He got paid.
Yeah.
This security is now done. The liability side matches the asset side.
Does that investor go away then?
No, he still exists.
He's still holding the security on your house.
No. It balanced out.
Okay.
It's the ledgering on it.
Eliminated that guy.
Yeah.
Okay.
Okay. But what does he get to do with this if he's a bank? Fractionalize it. Okay. But now you signed a new security, which is over here for $200K on the asset side. So now you're filling up this one, and that's with some other bank. Okay. That didn't get closed, though. Right. And typically, if you refinance, I'm imagining. Well, I guess it depends, but it probably wouldn't be exactly $200K. It would be minus equity or whatever the difference. Let's think about this. You owed 180, so 180 goes over here. So this would be no. 20 grand of credit would be over here. Yeah. So basically the 200K is still here, but you've got 20 grand on deposit here. Right? Does that make sense? Okay.
Well, then there's closing costs and refinance.
Right. Really, we can draw out 50 ledgers for every transaction.
Really?
Yeah.
Okay, so on each of these transactions, like for example, on the left side, the asset side of the 190K, now is there the separate escrow account that's being
This is the escrow.
That is the escrow account. Okay.
Okay. This is escrow. Anything that's held as an asset is typically escrow because the bank really can't do anything with it. That's why if you come back and claim it, they can't say anything. They got to just let you claim it because it was your asset. Okay? So if you claim the asset and take it back, they don't have the asset anymore. They can't sell it to the Federal Reserve to increase their funds. But you're actually doing them a favor because what happens when you claim this? You get it back from Treasury in the form of a check, and what do you do with the check? You deposit it. So they don't have to wait 3 years. They can now fractionalize it. Do you see how we're the cause of the banking problem? Okay? We're not claiming our funds back, so we're not getting them and we're not depositing them. So basically you have all these transactions. Like, you know how many assets, especially in the last 3 years? Think about this. 3 years. Take us back to what? 06? Yeah. How many loans of the bad loans happened since 2006 to now? A ton of them. But they can't get any of those funds. They're all locked up because none of us have claimed those funds back and deposited them into the bank. So we're hurting the banks.
It's crazy that they wouldn't want that to happen, for us to claim that back. They can actually, if we're going to redeposit it and then they can fractionalize it.
Well, think about this. Would you still be getting loans? Hold the microphone up, too, when you talk, so that the people on the video and audio can hear you. See?
Yeah, I have no idea.
Well,
you wouldn't.
No.
Yeah, well, you wouldn't. Yeah, well, you'd be paying cash for houses or whatever.
Exactly. We'd have enough. Think about it. They don't want the people to be super wealthy.
Right.
We need a graduated system.
Right. You can
If
just
we
pay
all
cash.
had millions of dollars, we wouldn't need the banks.
We are
We'd
the
be the
banks. We'd just be paying for the promissory note.
So
we would take them out of the,
it's a catch-22. Yeah. They're going to wait the 3 years because they'd rather wait the 3 years so that you keep coming to them for money. But in reality, if we were doing this, and see, the thing is, what they're really afraid of, and I don't mean the banks, but why the system doesn't educate you, because the public needs to exist, so to speak. And self-preservation for them is not telling you about this. Because what they're afraid of is people are greedy. Plain and simple, people are greedy. They get this money,
especially
they're going to hoard it. People will take cash out, they'll buy gold, they'll take it out of the banking system, and they'll hoard the property. And if we're not circulating these funds, the public dies. Now, if you're spending it all every year, no big deal. Everyone's happy because you're stimulating your community, you're stimulating the economy, the bank's getting their fill, and everyone's happy. But they can't rely on a bunch of debtors. You know what I mean? So
I'm really good at spending money.
Yeah, but they need you to. If you're getting this $100,000 back, spend it. Don't just hold on to it. Spend it. As much as you can spend in a year, you can get back.
Isn't that why they call it currency? Because it needs to go slow.
That's exactly where the term comes from. Like a current. Isn't it funny? What do you call the sides of a river? The banks. Okay?
It's like the circuit port. It's flowing currency.
Yep. It's interesting. Yeah.
Brendan, does that apply to credit cards? Like, WAMU just sold all their credit cards to Chase.
Uh-huh.
Now, is that actually a legal transaction? And does Chase now
Imagine if it wasn't, it wouldn't happen.
Well, I'm just saying hey, I feel dumb enough asking questions anyway, man, okay? Come on. All right, so...
You want to see how a credit card works? Okay.
Yes. Thank you. That's what I wanted to ask. Can I see how a credit card works?
Okay. What do you have to sign? Credit application for a credit card, right? So as soon as you sign it, they say they're going to give you a $10,000 limit. Okay. So here's their $10,000 what? Asset, which is what? The credit application. Okay. So that's the asset. They get the funds from the Federal Reserve. So now there's $10,000 sitting on the liability side. when you use your credit card, where do the funds come from? The liability side. So I charge $1,000. So boom. Now I got a $9,000 credit limit, which is basically, it's like a deposit account. That's my balance. But they tell you, you owe us $1,000 because they want to keep it even. They want to keep both sides even. So they send you a bill saying, yeah, send us $1,000. You okay, I'll send you $1,000. You send them $1,000, it's back up to $10,000 limit. You send them more than $1,000, what happens? They send you a check. Why? They have to keep it balanced. They can't even have 10,001 on this side because they've only got a 10,000 asset over here on this side of the account. So you send them $1 over, I guarantee you they're going to waste the ink and paper to send you a $1 check. Microphone to the back.
Yeah, when I send in my my check or over the phone checking thing to them, and even if it's like 5 cents or $1 over, they'll void that whole thing, and say just they can't accept it. Forget about sending me money or whatever. Accepting my check.
They didn't accept.
They
your
won't even
payment.
accept it. Now it's even further late, and another 15 days and stuff like that. And I'll be on vacation.
That's actually a great ploy for them to get you on finance charges, late fees, more interest. That's a great ploy.
Yeah, I'm like, you would think that they'd be happy having extra money,
No.
$100 or whatever, but
Nope.
they're like, it doesn't.
Has anyone ever had like a $25,000 limit card and charge it up and pay it off? Charge it up and pay it off every month. What happens to your limit? They drop your limit because they're not making any money off of you. Like this guy's a waste. Who gets the merchant fees?
Well, every bank gets part of that. The merchant pays the credit card.
Hold on. Like,
They get paid multiple ways. Every time you sign the agreement, that's a security. They just got paid for that. Regardless of whether you pay them 1 cent, they just got paid number one.
Mm-hmm.
The merchant then pays them anywhere from 3 to 5%, or whatever it is, 2.9 to 4%. That's payment number two. And then when you pay it, that's payment number three for every single credit card transaction.
Yeah. They're not making as much on the transactions, though.
Yeah,
not as much as they could be making with these.
But they still got
deposits.
paid 2 times for the
Oh, no, I'm
commensurate.
not-
I'm just
they
saying.
operate at 500%
Yeah.
profit. They're making money hand over fist every which way they can.
so if you were going to OID, can you go over the OID of a credit card account? Like, how does that work? Like, does it depend on when it's open?
Let's identify original issue. Okay, let's do that because there's some people in this room who I know probably weren't here on the first session. So let's identify when an original issue discount happens. Okay, so this is Brenda's bank account at Bank A. Okay, this is Bank A's account with the Federal Reserve. Okay, this is Bank B's account with the Federal Reserve. And this is Dylan's account with Bank B. Okay? So,
Exactly. It looks like a graveyard.
Crucifixion.
prepaid your sins. He prepaid your sins. That's the double-sided book entry. Okay, so let's say Dylan writes a check to Brenda for $1,000. Okay? So Brenda deposits the check into her account. Oh, okay, this is Brenda. Okay, so Dylan writes Brenda a check for $1,000. Put what? Oh, okay, D and B. Okay. All right, so now they bank at 2 different banks, right? Okay, so Brenda wrote a check to Dylan for $1,000. He deposits it into his account. Okay. The endorsed check is the asset. the funds in the balance are now the liability. Okay? Now, the way that the money actually flows, okay? She wrote the check, she handed it to Dylan, he deposited it. Here's the temporary credit, okay? Dylan's bank sends this credit or request for credit to the Federal Reserve. Federal Reserve goes, okay, no problem. We're going to increase your liability account, or this liability is the same as this asset over here. Okay? So this is the Federal Reserve's liability and Bank A's asset. Okay? That's the asset side. They got the check now. Okay? It has to balance. Always has to balance. But then they come over to Bank B's account, okay, in their Federal Reserve account, and they reduce it by 1,000. So they've reduced the reserves of Bank B. Now, by banking regulations, when your reserves get reduced, you must reduce your deposits by an equal amount. Okay? So they go to Brenda and they say, well, since you authorized this check, we're reducing your deposit. So they reduce Brenda's balance, which is the bank's liability. We're good? Okay. So Brenda's account got reduced by 1,000 in the deposits. Now, who wrote the check? Brenda. Who's holding the check now? The check came from Dylan's bank over to the Federal Reserve, through the Federal Reserve to Bank B. Bank B, this is Bank B. Bank B has this other ledger up here. We'll call this escrow. Bank B is Brenda's bank. She wrote the check. Okay? So this is Bank B's escrow account. Okay? It's not Brenda's account. It's Bank B's account. So it kind of belongs, with this account right here. Okay? This now has a $1,000 asset. What is the asset? The security. Okay? Now this is where original issue discount happens. Okay? This $1,000 is on an instrument. Okay? The definition of original issue discount is the redemption value minus the issue price. Okay? And how much did they pay Brenda for that? Zero. And what's the redemption value of it? 1,000. So they've withheld an original issue discount of $1,000 from Brenda. Right? She authorized the security by signing it. Okay? Now, can the bank do anything with this money? Why not? Because they don't have liability over here, right? They don't have liquidity on it. Okay, so they can't, so it's a security. In 3 years, they can turn this security into liability funds, which would then give them $1,000 on this side. Now they can fractionalize it.
How do they turn into liability funds?
They go through the Federal Reserve, says, yeah, we'll take that asset. And Federal Reserve gets the asset. They get a credit on their Federal Reserve account right here. Okay, or wait, I think I've mixed up the accounts. Yeah, this is actually the Federal Reserve account. These two accounts are supposed to be together. So this is their Federal Reserve account, so this now gets increased by 1,000 after the 3 years. Okay? So now they've got reserves of 1,000 they can fractionalize. Okay? Now, if Brenda declares that $1,000 back on a 1099 OID, then she gets that money back into her account. So she increases her deposits by 1,000, but that also increases the bank's deposits by 1,000. So, has the bank lost anything? No. They just got it faster. They didn't have to wait the 3 years to convert it. So now they've got some more funds in their Federal Reserve account in their credit. Yeah, we are. We're totally responsible. Creditors are responsible. So who's responsible for the banking crisis? We are.
What are the dates that tie into that 3 years as far as filing to get it on the 1099 OID?
Okay, if you're actually talking about filing for it, you have the year cutoff for the IRS is what? What month? April 15th. Now, April 15th is when for instance, if right now we're in 2009, right? But I can actually go back to 2005 because we haven't reached April 15th yet. Okay? No. Right. To go 3 years back, I can go into 05. So I can claim back everything from 05 up until April 15th. Then I can only go back to 06. Exactly. Exactly. And we talked about transition from one accounting system to another being 120 days. We didn't talk about that? Okay, we talked about in the first class. 120-day transition from one accounting system to another. What's January 1st plus 120 days? No, about April 20th, right? Somewhere around there. April 15th is the cutoff because they got to get the mail. You have to have it in the mail by the 15th, but they got to get it by the 20th. Because if they don't get it by the 20th, they can't balance the books for the year. And they have to have them balanced by the 120th day.
You have to file it by sometime in February?
You have up until April 15th to actually file your taxes. If you get it in at 11:59 p.m. on April 15th, well, I guess there's not many post offices open at 11:59. Oh, are they? Well, there you go. So you can get it in at 11:59.
So what would happen if the bank does not ledger the 1099-A?
Okay, now we're talking about A's.
Yeah.
Do we have any more questions about OID?
I do have an OID.
To get an OID.
Oh, to get... Okay. Well, let's move to that next. Okay, let's finish our OID questions.
So just if you had a corporation that only had 2 trustees, for example, one of those people does not sign the checks, the other person does, but the person that doesn't sign the check is the owner of the corporation, can they still OID that corporate account?
Is the owner on the account? Is his Social Security number attached to the account?
No.
Probably not.
Okay. But
'Cause
the person who signs the checks, if their Social Security is, they can get the OID?
You got to be careful what kind of corporation you're dealing with. If it's actually a big corporation...
No, it's just a 2-person corporation.
Oh, okay. 2-man corporation? Yeah. The person signing the checks can. If both are on the account, they both can, but they both can't claim the same money. Right. They can't both go, yeah, I'm claiming $10,000. Oh, hey, me too. Okay. That's not going to work. So, behind you.
So you mentioned in a previous class about the cutoff time for the processing of OIDs is like March or February.
You want to get it in the mail by February 20th because after March 1st, they don't process 1099s until November 1st. So they just sit there. Now, if you're not going to be filing a 1040 until the next year, it doesn't matter. But if you're going to try to follow up with a 1040, you're going to get a frivolous filing. Experience.
So if you're trying to capture 2005, we'd have to get our 1099 OIDs in like right away.
Yeah. You'd have to get them in the next, and hold up. Don't anybody rush into filing anything unless you understand what you're doing. Okay? It's not absolute. Now, 1099s, for the most part, are not calculated after March 1st, except 1099s that are marked corrected. So if it goes in after March 1st and it's marked corrected, it'll get processed by the IRS. I'm not telling you to mark any. I'm not telling you to do anything, for one. Yeah, I'm just telling you I've talked to the IRS on that. So what I'm talking about is what I would do and what I have done, but I'm not advocating anything. Okay?
Now,
unless you understand it. Yeah.
Do you process them electronically, file them electronically, or you do it by paper?
Can. Oh, do I personally?
Yes.
I'm signing up for my electronic account right now. I just got the application the other day.
And is it advantageous to do it electronically?
If you mail it in, you're looking at 3 weeks, 2 to 3 weeks before it actually gets scanned and into the computers. If you electronically send it in, 72 hours. So you tell me. Is it advantageous?
Yes.
I would say so. And realistically, you're probably all going to have to get electronic accounts or file through someone else next year.
How do you do electronic?
There's an application. I forget the form number on it. Oh, I'm not going to go through my email right now.
I have one more question about that.
Does that create an asset if we assign the application to the electronic?
Yes, it does. Because assigning a 1040 is an asset. Did you know that? 1040 is a claim.
So my question is, if you file a 1099-A on something, whether it's acquisition or abandonment, and there isn't an escrow account there, do you get frivolous filing, or does this nothing happens with it?
It's
like if it's an empty account,
right? If there's no asset, then it's really up to the people receiving. Okay, whatever you send in the IRS, it goes in their books. They just get it as here's an acquisition. Okay, your bank who receives it, they go, oh, this account is already ledgered out. We don't have an open balance asset or liability on this account.
So then they just respond with zero.
So there's really nothing happening.
But so you can do that. You can file that without getting into a frivolous filing penalties or.
It depends. Are you trying to claim it on an OID?
Probably.
Maybe. If there's no asset there, yes. I would say yes. They won't necessarily catch you, but they eventually will. Okay? Mm-hmm. So don't start filling out OIDs on assets that you didn't create. Because if you do that, they may send you a return. And you may be able to hold on to that. And you may even get to spend it all. But if they catch up in the books and they realize, hey, what the hell happened here? They're going to come back at you and say, hey, we sent you a $200,000 check. We need that back plus tax.
Sure. No, I got that. It's more of like if there's an account, like those accounts that I mentioned about, like if they're previous to the 5 or the 3 years, or if there's bank accounts that you don't know if they're open yet or not. You know, like on your credit report. Like
if you're doing an acquisition, it's not going to ever hurt you because you would never follow up an acquisition with an OID.
Right.
You would only follow up an abandonment with an OID.
Okay.
Okay.
But if you do follow it up, if you do an abandonment, you follow it up with an OID, they send you back money, and then you just put that away somewhere just in case they do want it back at some point.
What do you mean put it away? In
like
a bank account, right?
Put it back in a savings account or something where it just sits there for, whatever, however long. They can do that and then go, well, we have a mistake and send it back or whatever.
Yeah.
Okay.
But I'm warning you.
Yeah.
They're going to tax you on it too.
Sure.
Okay?
Right.
So, you may just be letting it sit there like, oh, I'm going to see if they catch my mistake.
Right.
And I'm just going to let it sit there. If you wait till then, they're going to come back and they're going to say, you owe us, $240,000.
Right.
Actually, it would be even more than that. Yeah, it would be like $260,000, $270,000.
Right. Yeah, 30% or something.
Yeah.
Yeah.
And now we're getting into A's. You had a question too.
Okay, I was looking through my account.
I had moved funds from one account to the other.
This question always comes up.
Well, because I was looking at how much came out.
Yeah. Check it
and
out.
So it was in the total, and there was another. There was a check that I had gotten that they had put a stop on it. That was also recorded as coming out.
Ah, you put the stop on a check?
No, a company put
that's
the
a
stop
deposit.
on a check that I deposited it.
Right, but when you deposit, you didn't. That's not yours. That's somebody else's.
But then they took
that'd
it
be
out
like
of my
Dylan.
account.
That'd be like Dylan trying to claim these funds over here that are Brenda's.
Right. So it was in my account. They recorded it as going in.
Right.
So they also recorded it as coming out since it wasn't honored.
Well, then it's a wash.
Yeah, it doesn't count towards anything.
Okay.
But I see what you're saying because it is marked as going out, and you're just adding up all your withdrawals.
I was just adding them all up, and I was wondering how does that?
Yeah, watch out for those because that's not legit.
So, okay. So when you file, and if you file the wrong amount, what happens?
If you file the wrong amount, how many of you?
Does it have to be on the penny?
How many people have accurately, to the penny, reported their income to the IRS? Ever?
Okay.
Did I answer your question? Now, if it's like $10,000 difference, you better watch out.
Okay.
If it's you're off $10, $100, even $1,000, nobody's going to catch on.
Okay.
Probably. I'm not advocating
So they don't
being
have,
off on your
when
account.
you file, they don't accurately look exactly at what they had in there for you, tied in with your social.
Well,
they don't.
What they're going to do, they may. I mean, they may look at the account.
Yeah.
That's their job, and right now they're being. This is why I'm warning you guys so much to do this right, because they're being extra scrutinizing on 1099 OID filings. Okay? Because so many people have made so many mistakes. You should have seen my first filing. It was so ass backwards. There's no way, by the way I filled out the forms, I should have ever got a return. And guess what? I got a return. Okay? And a visit from CID.
Did you pay tax on that?
No, they took. I didn't spend the money.
You didn't spend the money. Okay.
Yeah.
Did you have to give the full amount back?
Yeah, full amount back.
Last question.
Yeah. No, I actually didn't get a penalty on that because they actually sent me the money and they said because the account was reconciled before anything happened. They were kind of like, no penalty, but here's where you made a mistake. Was basically what happened.
So I bought and sold a house with a partner. So I would imagine half of the loan. How does that
You're
work?
both on that credit application?
We're both on that application. Not married.
You could claim half the funds, and he could claim half the funds.
Mm-hmm.
One of you could claim all the funds. Because when you both went on the credit application, chances are they took the funds from one number or another, or maybe they're both. Because realistically, it's not like the Federal Reserve has an account with your number on it and your name on it. The Federal Reserve's just kind of sitting there as a pool. And they go, okay, you're requesting credit for those two. Here you go.
So one person could claim that money, then?
Yes. Just like having two signers on an account.
Okay.
So I have a question regarding the 36 months time frame window for the OID. So we have our last refinance on the home was March of 06.
Okay.
So if it was March of 06 and 36 months, that's going to expire. Is it possible to actually reclaim those funds? That
You have until 2010. April 15th, 2010. Even though it was in March. Even though it was in March, you have until April 15th of 2010.
Okay. Got it.
At the fiscal year.
Okay. Got it.
Okay, there's a question up here. If you guys want to pass it forward. You. Yeah, you don't have a question? Yeah.
Actually, before you go to the A, just another question about that regarding when you purchase the house.
Go ahead.
What if the bank does not ledger their 1099-A after you are in order for you to go ahead and OID them?
Are we talking an abandonment or an acquisition? How would you know if they ledgered it? It doesn't. You sent in the report to the IRS that the funds were abandoned.
Right. You send in the 1099-A. Funds are abandoned. You follow it up with a 1099 OID to get the monies, and then what if 2 or 3 years down the line they say, "Hey, this bank is refuting it"?
They only have 10 days to refute it.
Oh, 10 days?
If you don't receive something in 10 days, then they're not refuting it. So they can't.
I'll just yell at them.
So then, technically, as I understood before, 36 months is when the bank then says, okay, this is abandoned and we take it, but we actually have more than 36 months
Yes.
to actually get it back.
Technically, you have probably a couple months over because it's the time between January and April is really the only leeway you have. So it could be 3 years and 4 months is the most amount of time it can be.
So if it was March of 06, so in March of 09, don't they then say, hey, this is abandoned and take the money?
No, they have to wait till 2010. They have to wait till the end of the fiscal year and not their fiscal year, but the IRS's fiscal year.
Okay, so it's really not exactly 36 months then, technically.
No, that's what the IRS calls testing time.
Okay.
They still have to wait till they can file.
Okay, got it.
Yeah.
Thank you.
Yeah, because abandonment is reported on a form, 1099-A. Okay.
What kind of paperwork you file for that?
What kind of paperwork do you file?
Yeah, what he's talking about.
Should I get into this? Okay.
Well,
I may mention, I'm going to mention some forms, but if you don't know how to fill them out, because how you fill them out is very important, okay? I'm just going to tell you the process, okay? What I would do, personally, and I'm not telling anybody else to do this, if I've got an asset sitting here, and it would be, let's say all the checks I wrote for a year add up to $100,000, okay? So I would put in first, before I do an OID, I would send in a 1099-A, an abandonment. I'm the lender, the bank is the borrower on that $100,000. And I would mark box 5 of the 1099-A, yes. That makes it an abandonment, okay? Once those funds have been abandoned, once I've reported those funds as abandoned, then I would follow up with a 1099 OID, because remember, these funds are abandoned and they were withheld. Okay? Now, let's say you're a W-2 employee and your employer withholds federal income tax. That's the federal income tax withholding, right? Okay. Are you the payer or the recipient on the W-2? You're the recipient, right? They withheld funds from you. You're the recipient, right? So the 1099 OID, you would be the recipient, and there's 2 boxes on the 1099 OID where the amount would go. I would put my $100,000 in box 1 as my original issue discount. Jeez. No, it's running out. So I've got $100,000 in my original issue discount, box number 1. Box number 4 on the 1099 OID is the federal income tax withheld. How much did the bank withhold of that 100K? 100K. They withheld it all. They didn't give you any of it. Okay, they're holding that security, the 100,000. The issue price was 0. The redemption value is $100,000. So the original issue discount is $100,000. The amount withheld is $100,000. However, I wouldn't put $100,000 in box 4. I would put probably $97,000 or something, $95,000 or something. And the reason I would do that is because that's what the IRS is used to. They're not used to getting forms where the amount and the withholding are the same. That flags in their system. They're like, wait a minute. You didn't get paid anything? There was 100% withholding? So that automatically triggers. Now, the reason I'm saying that is because right now, like I said, the IRS is getting so many of these filed wrong that they are beyond busy just handling 1099 OID stuff. If you do it right and you don't set off any of the flags by not being greedy, because what am I reducing? I'm reducing my return by reducing what's in box 4. Because box 4 is what's going to come over onto my 1040. Because I'm reporting box 1 as interest income, and box 4 is income withheld. Now, if I were greedy, I would want the whole 100,000.
Can you say that again about the box 40 goes to 1040?
Box 1 goes to interest income. It's listed on Schedule B. Okay. Box 4 would go to income withheld. Okay? And then when you pay the tax, you're going to have to calculate a tax based on the tax table on this $100,000. So you're automatically going to lose 35%, or actually off the $90,000. Let's say we put $90,000 in box 4. 35% of that's going to go to the IRS based on your tax table. And you're going to get back the rest. What's that? Well, you're supposed to calculate it. If you don't calculate it, they'll take it out. Experience. I actually tried not paying the tax on it. And they said, no, we recalculated your taxes. Seems to us you forgot to put in that you owed a tax. They were actually really nice about it. They didn't, no frivolous, nothing. They're just like, hey, you checked this. See, what happened was I was attempting to file as a creditor, but I'm not established as a creditor yet. When we learn to be creditors and you learn to prepay everything, you won't pay a tax because you're a creditor. The IRS works for you. And see, I was under the mindset that, yeah, I'm a creditor, thinking all I had to do was say it and that made me one. That's not how it actually works. And so I marked exemption 0, deduction 0, but in filing status, I marked single. And if you mark any of the filing statuses, it has an automatic exemption. So this is how they corrected me. They said, your filing status doesn't mark your exemption, or doesn't match your exemption. Okay? So they said, so we put your exemption in there for you. We took your deduction. They gave me my deduction. And because you took a deduction, we're going to tax you. Because we haven't even got into this, but gross income and taxable income are two totally different things. Everything that comes in is not taxable. That's what the Supreme Court says, okay? Gross income becomes taxable income when you take exemptions and deductions. Okay? So as soon as I marked the filing status single, I took a deduction. Now, then I went back to the instructions on the 1040. For filing status, it's not required. I thought, that's interesting. No. No. Okay. Everybody mark a filing status, take an exemption, do your taxes, and do your deductions. When you learn to operate as a creditor, then you can get out of paying taxes. But until you're a creditor, meaning all your debts are wiped clean, you're prepaying everything, then you can start doing creditor filings. Okay? But nobody in here is there yet. Okay.
So there is a place on that 1040 that says you don't file.
Read the instructions. Read the instructions.
So you basically have to pay off all your debts.
Yep. Pay off all your debts.
Just in your opinion, you're saying that the IRS is handling a lot of these forms now,
Yes.
more than usual.
Oh, a lot more than usual.
I'd like your description of the content of who's filing these. What amounts, what companies, and do all of the people who are processing these things at the IRS, because they understand how it works, are they all personally filing them themselves?
Good question. I don't know if IRS agents are filing this way.
But they know about it. I mean, if they're reading it and they're checking these things to make sure that they're accurate, then they understand the process. So.
Not necessarily. They just understand the forms and where to go to verify the amounts.
Okay.
They don't necessarily know what you're doing. They just know when they get a 1099, they need to go into their records and check. Is this recorded?
Right.
Does it ledger? Does it match? That's all they're checking for. They're not saying they don't know what's going on the form other than what's reported, a bunch of numbers.
Okay.
Yeah, they don't know that you're getting the money back on your mortgage. They don't know that.
So that's what I'm trying to get a gauge of, is at what levels of the system, whether it's with the IRS or at banks, does it require an operative knowledge of what you're talking about in terms of knowing what's really going on versus how many people can
CFOs know this. Well, I don't know if they necessarily know the OID process, but you ever notice how a CFO, which is basically a glorified accountant, gets paid millions of dollars, but your accountant gets paid $60,000 a year? Okay, there's a reason, because they know how to use your exemptions. That's what the CFOs are there for. That. Like a utility company, did you know when you receive a payment coupon on your utility, the funds are sitting there in an asset account? That's why they're sending you the payment coupon. What's a coupon? Doesn't it have a value on it? Right? And what's the value they put on the coupon? The amount you owe, right? It's because they already got the asset from Treasury or Federal Reserve. It's sitting there as an asset. They get you to pay in liability funds. They doubled the money. Okay? That's why CFOs get paid so much money. Not only that, they're making money off of all their employees because they're using all their employees' exemptions for credit. And again, this is something, that's why a CFO gets paid the big bucks. He knows how to use all his clients and all his employees' exemptions to make the corporation money.
That's actually why I want to legalize it.
Oh, yeah. Oh, yeah. Now, you know the real reason they built the wall, right? Yeah, they don't want them out. They don't want them to leave. Because that's in more exemptions. The more exemptions they have, the better. That's why they're like, yeah, give them Social Security numbers, no problem. Give them all numbers. Because as long as they have numbers, they're an exemption. And we can make money off of them. Even the county uses your exemption. The county, the state.
Well, then they can open bank accounts, and then the banks can get the escrow accounts, and they're never going to claim them.
And then on it goes. And then we create more and more public debt. You guys know how much hasn't been claimed? I would say, and this is just my off the wall, but every time you don't claim this money back, it creates public debt. What's the public debt total? 10, 11 trillion? DTCC holds assets. We haven't gotten to DTC yet. We'll talk about that, and we'll learn all about the DTC. That's where your birth certificate gets deposited, is DTCC.
Brandon, you had mentioned, and you don't have to get into this in detail because I know time's getting on, but operating as a creditor in total, once you're completely out of debt. Now, do you have to go into your master file with the IRS to see if there are any liabilities that you don't know about, or is it simply just paying off all outstanding loans or discharging all of that and then operating as a creditor in full?
I don't know if I would go to the master. You can go to the master file, but the thing about the master file is it's not specific to your account. It's specific to your number.
Right.
So you're actually sharing that number with like Afghani drug dealers and gun smugglers and everyone that they're tracking outside may be sharing a number with you.
Mm-hmm.
So everything on your IMF isn't necessarily yours. Like there was a guy at the Winston Shrout seminar on his IMF. It had like $9 billion on there, and it had him marked as an Afghani heroin dealer or some shit like that. You know what I mean? He's like, what the? You know, it didn't make any sense, but it was because of the number. It's not because of the name. Think about it. There's only it's a 9-digit number, so there's limited numbers, but they reuse the numbers. But it's the name and the number together
quick,
make
though,
the account.
Since you said you don't start operating as a creditor because you're still in debt, could you just clarify that point so people know the difference of like when they can? Is it like this is a demarcation point? I'm a debtor, and then I transition because of what?
When you've settled and closed all accounts, and those that you need open, like your electric, your gas, you don't want to close those because then you won't have electricity and gas. But all the ones that you need open, you will have them paid a year in advance. So you'll have your electric paid a year in advance. You'll have your gas paid a year in advance. You'll have your cable paid a year in advance. And your property taxes a year in advance.
Are you there?
No, I'm not there yet. But I'm getting there. That's what I'm working for, and that's what we are working for because we want a community that works. We don't want one that's falling apart and collapsing on itself.
Would we be getting rid of our credit cards then?
If you want a credit card, I would do a, what do they call them? Secured credit card.
So you pay into it when you just put it down and pay it all.
Would this be the same model?
But realistically, that's still an open debt. Just use a debit card. Yeah, credit card, because you have to still sign the credit application.
Would this be the same model for like a student loan?
Yes.
Same thing. You can claim those. Wow.
Student loans, just like a loan for your house. Just you loan them the money.
Briefly on the birth certificates in DCC, I went and looked in the files what I had, and I have a birth certificate with my footprints on it and my mom's
That's
fingerprints.
application.
That's the application.
That's the application.
They have what then? The actual certificate.
The certificate's
that you
a
get from
bond.
the county. You get the.
That's a certificate of live birth. You had an application of live birth, which has the footprints and the fingerprints and the signatures.
And when you send away to the county the thing that looks like it's made off of a microfiche, they have the original.
And
of that.
have you guys looked? How many of you have gotten your birth certificates out of Orange County? None of you?
I have one from LA County.
If you read at the bottom, it says AmWest Banknote Company. Because it's a bond. It's bond paper. It's on a bond. It's even got a bond number on it. Okay.
If I receive invitation from banks to open to borrow money for 0% interest for a certain period, why wouldn't I do that and invest it where I can make with that interest-free money? What would be the...
I don't know. Why wouldn't you?
No, you said get rid of the credit card. So,
I'm saying for me, because I want to be totally on the credit side, I'm not. Check this out. We haven't discussed this. You can get the loan because you can close it in less than 30 days. Yeah, you can do an acquisition on that account and close it out. It's no longer public debt.
Okay.
We haven't talked about that too much, but
okay. Can you explain to me what happening? Like I had a loan, interest-free loan, and then when they start charging me interest, I close it, I paid it off, but they still charging me like it was auto pay. So like do not miss the payday. I put it so they will withdraw it from my bank account, and I closed that. And I called them twice, like why you still charging me? And they say, oh, sorry, we'll correct it, and they keep doing it. So what's the game there? I cannot understand. Like I owe them zero, but
and they're taking automatic withdrawals out of your account.
Yes, they keep doing it for 2 months now. I paid it 2 months ago.
I would contact your bank and say, hey, these are not authorized transactions. Stop them from taking this money out of my account.
Because they do not react to my request to
Yeah, it's it's. I equate that to years ago. I signed up for free internet, or no, it was the cheap internet, like back in the dial-up days, $9.95 a month, yeah, like Net Zero or something, and it's no problem to get an account. Go to the website, you fill out the form, boom, you got internet access. Yeah, trying to get rid of that account is a whole other matter. There's nowhere on the site to do it. I'm like, wait, I could open it no problem on the website. Nowhere on the website to close it. Call them up. They sent me through this whole runaround. Oh, yeah, well, sorry, we can't close it right now because our system is down and this, that, and the other. And I'm like, okay, call back the next day. It literally took me 2 or 3 weeks to get an account closed that took me 5 minutes to open. So it's business. Don't take it personal. Yeah, doesn't mean they're going to take action on it, but yeah, you can.
Where can you find where can you find the TTNL for your account?
Track TTNL transactions? Yeah. You might want to get in touch with IRS Technical Support Division. They're the ones who run all the TTNL transactions.
Runs all the what?
TTNL. That's Treasury Tax and Loan accounts. IRS Technical Support Division.
Can you go back to the credit cards, just to talk about like when that starts?
When it starts.
Just to revisit credit cards for a second, like when you open that account, if you're going to OID that, like how that works, if it's like if you open it, say, in 2005, and it's been a revolving account, and like you maxed it out, say, in 2 years, and it's just been sitting there, and you pay the interest with just the minimum payments just with your bank account, but then that full amount of that credit limit's still there, maxed out. Would you be able to OID that amount without interest?
What was the original issue discount event? Now, you guys really need to understand this. An original issue discount happens when there's a security created and you authorize the creation of it. Okay? If you didn't authorize the creation of the money, you don't OID it. Plain and simple.
Well, you did, though, by signing the application and getting a credit limit.
That would close the account. Are you looking to close the account? Then you would do an acquisition on that account.
Okay. But what if you still owe on it? Like if there's still the balance?
No. If you do, okay. So let's say let's say your credit limit is $1,000, okay, and you've maxed it out, right? So you've actually spent this $1,000, and it's now down to $1 of available credit, right?
Yeah.
Okay. You do an acquisition. What are you acquiring? $1,000 asset. If I acquire this asset, how much can they hold over here on the liability side? So yeah, did you answer your own question? Would you still owe them money? No, because the account's gone. You just did an acquisition on it, account's gone.
You're just doing an acquisition on it then. You're never doing it. You're just doing an acquisition on your credit card accounts to close them. You're not doing an OID. Abandonment.
Okay. Okay. Obviously, I'm not explaining this very well. If you use the card, you're authorizing the creation of money. Okay, it's just like writing a check. Every time you use your debit card, every time you use your credit card, it's like writing a check. So it creates this security. That is an original issue. Okay? The discount is there was a $0 issue price. The redemption value is $1,000. Okay? So, what can you OID with a credit card? What you charge. Okay?
Plus the original application.
The original application, you could do an acquisition. You could do an abandonment on it. But I would say let's not be greedy. And probably, if you would just want to close accounts, do acquisitions. Because if you're going to leave it open, just leave it open. Use it up, charge it all the way up, get the money back, pay it off. Charge it up, get the money back, pay it off. Then everyone wins. Banks, credit card companies, and us, and the community because you're spending it.
Well, that's what I was asking. Is, I mean, if you max it out, that's the amount of purchases you've made. You know, itemized. You can say $1,000 of this and 500 of that and whatever. So you're OIDing that purchase limit because you've maxed it out.
Just get away from the limit.
Okay.
It has nothing to do with the limit.
Okay. Okay.
Whatever you charge.
Okay. Well, but if you don't pay it off, and it's just you don't use it, it's that whatever you've used up to that point.
The transactions, because remember, you're also putting payments in on the credit card. You don't OID those unless they're coming out of your bank account, but that's an OID on the bank account. Has nothing to do with the payments on the credit card.
Okay.
So the limit really has nothing to do with it because I could charge, let's say I have a card with a $25,000 limit. I can max it out every month, and by the end of the year, I've used close to $1 million of it or whatever. You know what I mean?
Yeah.
So
it's
each transaction.
Got it.
What's that?
That includes financial.
Banking fees, finance charges, you're authorizing those funds each time. Yes. Well, yeah, I guess NSFs too.
So, question regarding the credit card. So, if you were to max it out, you can only do the OID during tax time, correct? Once a year?
What do you mean by that? Like claiming funds back?
Yes. Or can you do it monthly?
On the credit card.
Monthly OID, I
No. It's just once a year, right? With taxes, right?
Yeah.
Okay. Got it. So if you were to charge up a credit card in a month, you would actually, and if you didn't have the funds to pay it off, you could OID at the end of the year for the entire amount of all the charges that you added up. But otherwise, if you charged it every month and paid it off, you would then OID at the end of the year all the checks that you wrote to pay off every month
on your bank
account,
right?
And then you could also OID all of the charges of that year on the credit card.
Yes.
Correct. Okay.
Wait, but if you owe $1,000 after a month and you can't pay it, and you wait till the end of the year to try to get it back, you now owe like $1,300 instead of $1,000. So,
You're making
or
special
more.
payments with your bank account. You OID your bank account.
That's actually a good point.
Yeah.
Because that interest could be considered you're authorizing the creation of those funds too.
Right.
Be careful with that, though. Be careful with that. Make sure you understand what you're doing, what you're reporting. Microphone back there.
So corporations do quarterly taxes, and I just heard what you just said, so I may not even ask it. But if you're doing your quarterly taxes, can you do this process quarterly then of different things that you want to close out, different things you want to OID? I mean, just making the record, I guess, just recording everything quarterly would be much more helpful.
You can make that decision. I don't see it as helpful or damaging in any way. Whatever you feel you want.
You can't OID all the interest and fees that accrue from not paying a few times or whatever. It's just basically the simple charge itself.
I'm not saying that. I'm saying make sure you understand what you're doing.
Got it.
Are you going to go through the specific procedures for the OID?
What time is it?
11.
Okay, yeah. Well, let's wrap it up. I've got a document here I want to read this because this is going around the internet. Actually, this is kind of old, but okay. 1099 OID fraud based on unfounded strawman accounts, except for value and redemption arguments. The IRS cautions taxpayers to avoid getting caught up in a tax fraud disguised as a debt payment option for credit cards or mortgage debt. Do 1099 OIDs pay off credit cards or mortgage debt? No. Don't try to use them for that. People think the OID is some kind of fix-all. You just fill one out and send it off and it's going to fix your problems. No. But listen carefully what they're saying here. The fraud is also marketed as a way to reduce taxes or pay outstanding liabilities. Is this for reducing taxes or for paying liabilities? No. It involves the filing of Form 1099 OID, original issue discount, and or bogus financial instruments such as bonded promissory notes or sight drafts. Have we talked about any of that? No, don't do it. This fraud has evolved from an earlier frivolous argument that a straw man bank account has been created at the Treasury Department for each U.S. citizen. Have we discussed a straw man bank account at Treasury? No. And that individuals could use such straw man accounts to pay debts and claim withholding credits. Are we using a U.S. Treasury account to pay debts or claim credits? No. The IRS addresses the straw man argument in Revenue Ruling 2005-21 and Revenue Ruling 2004-31 and discredits the use of this position for income tax purposes. What do we say about going into jurisdiction B, talking about jurisdiction A? Insanity. Alternative reality disorder. Okay? You don't talk about straw men with public entities. Just like people who go in before the judge and goes, I'm not that straw man. Why do you put my name in all capital letters? That's not me. The judge is going, yeah, you're incompetent. Okay? Yeah, psych eval, alternative reality disorder. Okay, so that's one. Okay? Does this notice affect anything we've discussed? No. Okay? I don't know if I've read this one. The U.S. Department of the Treasury, in parentheses, Treasury, Office of Inspector General is investigating incidences whereby individuals are using fraudulent Treasury-related financial obligations. What is a fraudulent Treasury-related financial obligation? Some kind of something you're trying to pay with? Okay? Or accounts to attempt purchases or pay debts. Is that what we're doing? No. Fraud perpetrators across the nation have recently begun to use fraudulent promissory notes and or private bonds as vehicles to defraud investors out of hundreds of millions of dollars. Have we talked about doing that? No. And please don't. The Department of Treasury is also aware of several fraudulent schemes that involve what are claimed to be securities issued or backed by the Treasury Department or another part of the U.S. government. Are we talking about instruments issued by Treasury? No. These scams have been directed towards banks, charities, individuals, and companies which seek payment on the fraudulent securities. Sample fraudulent documents which falsely utilize names of Treasury officials are provided below for reference. Oh, I actually saw these too. And I know one of the guys on one of these accounts. That's funny. I was like, oh my God, they got his name up. Like they had the fraudulent instruments, like, click on here and you could see an example of the instrument. And the guy's name, I know the guy. We're not going to talk names, and no, it's not. Sample fraudulent documents which falsely utilize names of Treasury officials are provided below for reference. These documents are not valid negotiable financial instruments, and recipients should not respond to nor act upon such documents. In addition to browsing the documents below, you may visit the official website of Bureau of Public Debt. Have we ever talked about dealing with the Bureau of Public Debt? Does anyone know what the Bureau of Public Debt is? It's the public side of Treasury. If you talk about the Treasury in public, guess who you're talking about? Bureau of Public Debt. So remember last week, was it last week, the week before, I showed you a money order? And I told you, don't use these. They're not for use in the public. These are private instruments. Okay? To be used for private banking. Okay? Blah, 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 public debt. For more information on this topic and how to avoid becoming a victim of this type of fraud, go to the Bureau of Public Debt. So, and whenever you guys get one of these, I'd love for you to bring them up because I'd love to break down the language and see what they're saying. So see, right here they're talking about the 1099 OID, but never did they mention the actual legitimate use of the 1099 OID. They talk about people trying to use it to pay debts and all these other things. Again, what is the Data Integrity Board? What are the watchmen on the wall for? Does anyone know? What's the watchman on the wall? They protect the public. The watchman on the wall protects the public. The IRS is a watchman on the wall. Judges, watchmen on the wall. They're here to protect your interests. Okay? If you start, and like I said, like when I told you about the resources page on the Creditors in Commerce website, be careful because you're going to come across people telling you to do this stuff. Okay? Don't do this stuff. Don't do anything you don't understand. If you can't make sense of it, somebody says, oh yeah, all you have to, you'll hear someone ask a question, oh my God, I've got a court case and I need to, oh my God. And they're like, oh yeah, all you do is fill out a 1099 OID and send it into the court. Okay? And that's where these kind of letters come from. Because people don't know what they're doing. They've heard about, the thing is, because there's people out there having success with OIDs and getting money back, they don't know what the OID is for. So they think it's some kind of monetary instrument they can use to settle their debts or to make any problem go away. And I'm here to tell you that's not what those tax forms are for. We just discussed what original issue discount is. And none of the things that they're talking about in here are the things we're talking about. And like I said, there's going to be people who tell you, do an OID for this, do an OID for that, do it this way, do it that way, fill it out this way, fill it out that way. Unless you understand what they're talking about, like I said, and the only reason I can tell you about these mistakes is because I've made these mistakes. I heard about people getting money back, and I filled them out wrong. Completely wrong. Upside down and backwards wrong. Okay? So I know from experience, you do it wrong, they're going to nail you. Okay? So know what you're doing. Don't pursue anything you don't understand. Now, and remember, creditor takes responsibility. So take responsibility for knowing and understanding everything for yourself. I'm a crackpot. I have alternate reality disorder. Okay? Don't listen to anything I say. Learn it for yourself. Read the Treasury documents. Read the Federal Reserve documents. You know how I learned how to do all this? What I explained to you tonight? Federal Reserve publications and IRS publications. That's the place to go. They're the ones who know it. George Smith on such and such a forum making claims about what to do with your 1099 OID, I wouldn't take his advice. I would go to the IRS. I would go to the Federal Reserve. I would go to the Treasury. Get your answers from the people who know. Okay, we'll wrap it up. A couple more questions. Last question.
4 minutes.
Oh, 4 minutes. Go ahead. Where's the microphone? Microphone. Oh.
Going back on the what's OID-able and what you can acquire, does insurance fall in the same? I mean, you put an application out for insurance, you get qualified for $1 million worth of insurance.
Yeah, we'll talk about that. Yeah, it is the same thing. You are creating funds. Actually, when you make a deposit into the bank account, you know where the FDIC money comes from? You created it. So your FDIC insurance is your creation. Mm-hmm.
When you close out a credit card with the 1099 OID.
Wait. Say that again?
a 1099A, what response, what are you going to get back from the credit card company? What are they going to send you? They're going to say your account's
You should get a zero balance. If you don't, suspicious activity report. That's what I would do personally. I'm not telling you to do anything.
Why do you have the resources on your website if they're not reliable?
Because there are some things you can learn from, because there's a much wider world out there of commerce, and some people do know what they're talking about, and it's almost better for you to be able to discern. You know what I mean? I'd like you guys to go ahead and explore those things, but discern for yourself. Like, this guy's a crackpot, you know, or I'm not going to do that. Like I said, anything that sounds like it's adversarial, you guys, realistically, I could think of maybe 2 or 3 other people in this entire commercial movement that I'm aware of that speak like creditors, who act like creditors, and who are giving you this same message. They're very few and far between. Most people are like, the United States is evil, we need to go to war with them, we need to destroy them, we need to go back to the Republic, we need to be back on gold. They don't know what the hell they're talking about, okay? As far as I'm concerned. As far as I'm concerned, the system we have is a perfect system. It's just our lack of understanding and our irresponsibility have created the situation we have. Because realistically, if we went back to the gold standard, we'd all be sorry. I guarantee it.
It's worse than fractional.
Yeah, it's way worse. Yeah, there's definitely not enough gold. And people would hoard it. It wouldn't be in accounts.
Can you tell us, when you saw the documents that they had on the website that were fraudulent, what made them fraudulent, or what were they doing in those documents?
They were private instruments. The one I saw was a private instrument that should not have been used in public.
I see.
Oh, might have been. No. Actually, it looked like a BIC kind of instrument. Yeah, but it's a private instrument. Okay, let's wrap it up. 2 minutes,
Okay.
1 minute, 1
All
minute.
right, just...
we're time.
Okay.